rise? Welcome to the 2023 public hearing on civil legal services. Presiding today, the President of the New York State Bar Association, Richard Lewis. Presiding Justice of the Appellate Division, First Department, the Honorable Diane Renwick. Presiding Justice of the Appellate Division, Second Department, the Honorable Hector LaSalle. Justice of the Appellate Division, Third Department, the Honorable Christine Clark. Appearing remotely is Presiding Justice of the Appellate Division, Fourth Department, the Honorable Gerald Whalen. The Chief Administrative Judge of the Unified Court System, the Honorable Joseph Zayas. And the Chief Judge of the State of New York, the Honorable Rowan Wilson. The hearing will now begin.
Please be seated, everyone. Welcome and thank you for coming. I'd like to acknowledge the presence of a few other people besides my colleagues here on the bench and President Lewis. The Honorable Edwina Richardson Mendelson, who is the Deputy Chief Administrative Judge for Justice Initiatives. The Honorable James Murphy, who is the Deputy Chief Administrative Judge for the courts outside of New York City. I don't see her, but I believe, oh, I'm sorry, I do see her. I just don't have my glasses on. The Honorable Ann Minahan, who is the Administrative Judge for the Ninth Judicial District. Helene Barnett, who is the Chair of the Permanent Commission on Access to Justice. The Honorable Fern Fisher, who is a member of that commission, former judge of the Housing Court, and all-around advisor on all sorts of things. And I also wanted, although they're not here, I wanted to thank and acknowledge the lawyers and legal assistants from Sullivan and Cromwell who assist the commission and were instrumental in helping to prepare the materials. Jessica Klein, who is special counsel and head of pro bono at the firm, Madeline Jenks, an associate at the firm, Marissa Torelli and Tessa Shimuzu, who are litigation legal assistants. And then also the commission staff counsel who is assisted with hearing preparation, Rochelle Klempner and Barbara Millet. Barbara is here. So thank you all again for coming. And I wanted to start with just a few brief remarks before we begin the more interesting part of the program, when you'll hear from people who actually know what they're talking about and people who've been the beneficiary of legal services. I think that in some ways is the most interesting part of today's hearing. So as you all know, Chief Judge Lippman created the Permanent Commission on Access to Justice, and over time obtained $100 million annually, now up to $112 million, to begin to address the need for representation in civil matters for those unable to afford a lawyer. I was privileged to serve as a member of the commission for a few years and see its work firsthand. Along with Helene Barnett, I attended several of the national conferences on access to justice, and I can report that no other state comes close to New York's commitment. I can also report that New York's commitment falls far short of any conceivable measure of need. The Commission has been working for more than 2 years to develop a rigorous conservative estimate of what it would take to provide civil representation to persons at or below twice the U.S. poverty line for the most pressing types of matters, including eviction, consumer debt, child support, and disability benefits. The Commission estimates that nearly an additional $1 billion annually would be required in New York. Myriad studies document the magnitude of the need, the tremendous deficit faced by unrepresented litigants, and the social consequences that result when the better outcomes that are available to represented litigants are unavailable to unrepresented litigants. I'm not going to restate any of that information today. You will hear later on from, as I said, people who know much more about this than I do. We should not forget, though, that civil legal representation is a means to various ends. And at the highest level of abstraction, everyone shares the same objectives. We want New Yorkers to have stable housing. We don't want them sleeping on the streets. We want New Yorkers to have food, not to starve. We want families to remain together safely. We want people to receive governmental benefits to which they are entitled. We want them to be productive and engaged members of our society. Our social problems, crime, homelessness, food insecurity, mental and physical illness, are not new. They are all interrelated in both cause and effect, and legal representation standing alone, whether civil or criminal, will not eliminate those problems. But legal representation gives people a chance for a better outcome, a chance to avoid or climb out of the spiraling abyss of our social ills. In conjunction with other programs, such as an increased supply of affordable housing, increased wellness resources, early support and intervention programs for parents who are finding it difficult to raise children, the benefits of civil legal representation can be multiplied, and quite possibly, the need for criminal legal representation may be reduced. The conclusion of the United States Department of Justice, backed by very substantial independent research, is, and I quote, "Ensuring access to legal solutions can not only improve outcomes for those who would seek assistance, but it can also save public dollars in the long term by preventing problems like homelessness or health issues that can be extremely costly and harmful to individuals and the public." Among the 50 states, New York's poverty level is 14th from the bottom. More than 13% of New Yorkers live below the poverty line, almost double the rate of our neighbor New Jersey. The president of a much poorer country than ours, Nelson Mandela, once observed, "Like slavery and apartheid, poverty is not natural. It is man-made, and it can be overcome and eradicated by the action of human beings." Poverty is a cause of, and is exacerbated by, most of our social ills. Greater provision of civil legal representation is one step we must take to build a stronger, healthier, and more equitable society. So with that, I would like to begin the programming by welcoming our first speaker, Ronald Flagg, who is the president of the Legal Services Corporation and traveled here from Washington to be with us. Thank you very much, Mr. Flagg.
Good afternoon, Chief Judge Wilson, Presiding Justices LaSalle, Renwick, and Whalen, Justice Clark, Chief Administrative Judge Zayas, and President Lewis. Thank you for inviting me today to discuss the urgent need for civil legal aid here in the state of New York and throughout the country. I am Ron Flagg and serve as president of the Legal Services Corporation. And today I will largely be discussing the needs of civil legal aid on a national level, but I look forward, as I'm sure you do, to hearing the New York State-specific reports that Chief Judge Wilson referred to and that will be presented shortly. LSC is the largest funder of civil legal aid in the United States. We fund 131 legal aid programs operating over 900 offices across the country. Here in New York, there are 7 LSC-funded grantees that serve low-income individuals in every community. And of course, those grantees are also supported by the funds that you help appropriate. While the first sentence of the U.S. Constitution identifies the establishment of justice as a priority, unfortunately, as you all know, the principle of equal justice has become less and less reflective of what we actually see in the operation of our courts throughout the country. In particular, in our civil justice system, economic means too often dictate the viability of one's legal rights. People living in poverty are reminded of this painful truth every day. Some of the largest client populations that LSC grantees and other legal aid programs serve include domestic violence survivors, veterans, and elderly individuals. The access to redress for survivors fleeing the violence of an abusive partner, veterans seeking a benefit that they earned for their service, or elderly people protecting their structured income should not turn on the means available to them to pay a lawyer. And yet far too many people living in poverty are forced to face life-altering issues, bet the company cases for their families on their own. In 2022, LSC released its Justice Gap Study, which examines the volume of civil legal needs faced by low-income Americans and measures the shortfall between those needs and the legal resources available to them. What we found was truly stunning. Nearly 75% of low-income Americans across the country face at least one civil legal issue, a significant civil legal issue every single year. And yet a striking 92%, let me repeat that statistic, 92% of those life-altering problems receive no or inadequate assistance, leaving individuals to face these challenges alone and often with devastating dispositive consequences. Let me share another, what I find shocking metric and evidence of the justice gap. Nearly 50% of individuals seeking help for their legal issues are turned away by legal aid programs, including ours, without any assistance due to resource constraints. And again, soberly, this nearly 1 in 2 turnaway rate substantially understates the justice gap, because it doesn't reflect the millions of people who don't know that they're necessarily facing a legal issue. And even if they understand they face a legal issue, they may not know of the availability of legal aid or how to get to legal aid's door. Now, you might wonder, does getting legal assistance really make a difference? In a system designed on the premise that people will have lawyers, not having a lawyer can often be dispositive. As we look around the country, in many landlord-tenant courts, over 90% of unrepresented tenants lose their homes. Conversely, in those few jurisdictions, including at least a couple here in New York State, where people do have representation in eviction cases, by and large, 80% or more are able to stay in their homes. That's a big difference. And that we see that same difference in other cases, be it family cases, eviction, you name it. These tragic justice gap data are a direct consequence of our country's chronic underfunding of civil legal aid. Chief Judge Wilson made reference to the underfunding of legal aid. Let me give you the national perspective on that issue. In FY 1994, Congress provided LSC with $400 million. 1994. 30 years later, our appropriation has only edged up to $560 million. In other words, we haven't even received remotely enough funding to keep up with inflation, much less the multiple recessions and the pandemic and the growth in legal issues that have occurred over the last 3 decades. Congress currently appropriates as much money for civil legal aid as Americans spend every year on Halloween costumes for their pets. Halloween costumes for their pets. This underfunding has also caused our grantees to fall behind in providing competitive pay for employees. Civil legal aid lawyers continue to be the lowest category of lawyers in the legal profession, earning less than public defenders and even other public interest lawyers. Too many law students graduating with increasing debt simply can't afford to become legal aid lawyers or remain legal aid lawyers. And unfortunately, the situation is not getting better. COVID has widened the justice gap. Our 2022 Justice Gap Study revealed that 1/3 of all civil legal problems reported by low-income Americans are directly related to the pandemic. And we see this by example, and particularly in eviction cases throughout the country. Housing issues have become, even more than they were before the pandemic, the largest area of our grantees' work, now representing more than 41% of the case closings for our grantees across the country. And here in New York State, we see that in even greater measure, with 49% of the closings by LSC grantees falling in the housing category. And with eviction moratoria expiring and emergency rental assistance depleted, this trend will likely accelerate. And of course, the devastating effect of evictions and housing problems aren't limited to housing. Without a secure roof over their heads, individuals and families experience worse health outcomes, higher unemployment, and educational struggles. We are also seeing a dramatic spike in domestic violence across the country. Domestic violence cases have been steadily rising over the past decade, a trend that worsened during the pandemic when many survivors were forced to quarantine with their abusers. The lack of representation has become a tremendous burden on our courts, and again, you know this better than I do, our judges, our administrators, and everyone involved in the civil justice system. It is no wonder why the Conference of Chief Justices and the Conference of State Court Administrators, along with, and note this statistic, 37 bipartisan state attorneys general. How many issues do you think unite 37 state attorneys general at this point in history? All of them asking for increased funding for LSC. We have heard from legal professionals from every state and territory in this country, and their message could not be clearer. Our system cannot handle the demand of low-income Americans facing civil legal issues on their own. And this is true in rural areas as well as densely populated urban communities across the country, and of course, this great state has many of both. We know that while the demographics of the individuals served may differ from community to community, the legal needs of people living in poverty are the same. Again, taking housing as an example, everybody understands that New York City and Washington, D.C. and Los Angeles face significant eviction issues, but what people often fail to understand is in rural areas across the country, we see equally severe housing issues. Rural communities often constitute what we call legal deserts. The inadequate access to legal services due to geographic isolation. 40% of the counties in the country have fewer than one lawyer per 1,000 residents. A lawyer, not a legal services lawyer, any lawyer. And in 10 states, some counties with large rural populations have no attorneys at all. That is why LSC has worked with our rural grantees as well as state and local partners to address these legal deserts. For example, our technology initiative grants are often used by grantees to develop new innovations to empower and improve services to low-income rural residents. This is exemplified here in New York, where LSC recently awarded Legal Aid Society of Mid-New York a technology initiative grant to create a coordinated online intake portal for the 6 funded LSC providers outside of New York City. The portal will focus on eviction services in the state with an eye to ensuring that applicants will not be bounced between service providers and miss timely pre-hearing assistance. Like other legal aid programs across the country, our 7 funded New York grantees cannot fully meet the legal needs of the communities they serve. The funding that you, the judiciary, awards to these organizations and other legal services providers around the state is critical. Given the justice gap data I have shared, we need to devote far more resources to civil legal aid. I strongly advocate for an increase in JCLS funding. The very existence of the Permanent Commission on Access to Justice, as well as today's hearing, evidences that you take this problem seriously. And the Permanent Commission plays a critical role in overcoming the barriers to which I have referred. I don't want to sugarcoat this. The long-term effects of a widening justice gap jeopardize the sustainability of our democracy. We saw in our justice gap study that only about a quarter of people living in poverty believe they get a fair shake from the justice system. Whether that's true or not, that's their perception. I believe we are up to meeting this challenge, and I thank you all for allowing me the opportunity to discuss this urgent matter with you today. Again, my thanks.
If you would stay for a question or two in case the panel has any, I was going to ask you whether you can think of ways to reduce the cost of it. My impression is that if you look back 50 or 70 years, people were resorting less to the courts for things like this than they used to, and that's part of, obviously part is exactly as you described, a drastic shortfall in funding that hasn't kept up with inflation. But on the other side of the equation, it seems to me there's also a greater use of legal process, and it's become more expensive. Are there ways that you've looked at or thought of to try and reduce the costs somewhat?
Well, I think that's a great question. I think we really need to be thinking of 2 overarching approaches, both of which relate to your question. One is we need to rethink our dispute resolution model. And again, I'm not advocating for anything specific here, but we know that there are online dispute resolution models, and don't get me wrong, there are disputes for which a human judge and people playing, carrying out your role are indispensable. But we need to take a a look at the way we resolve the wide range of disputes and see if there are other models of dispute resolution that might be less expensive and where we can level out the playing field more easily. And then second, we need to think about, even without big changes in the dispute resolution model, how we deliver legal services. The pandemic has been helpful in forcing all of us to think creatively about how to do what we do more efficiently and better. And obviously, remote hearings, I mean, we're seeing the benefit of a hybrid hearing today. And what would have seemed like an anomaly 5 years ago now is something that is pretty routine, and I think if used properly, benefits and is far more efficient for the system.
Thank you.
I have a comment, not a question really, but it's just to commend you on the Justice Gap Study. As you say, we don't know if some of those answers are true, but we need to know what the public thinks in order to better serve them. And I agree that some of those statistics were indeed stunning. So it was enlightening for me. Thank you.
Thank you. It's served as really a benchmark for LSC as well as judges and others. The President of the United States has cited it, so it's probably a good investment.
Thank you.
Well, again, thank you very much.
Next is the Honorable Richard Rivera, who is the supervising judge for Family Court in 3rd Judicial District and also a member of our Franklin H. Williams Commission. Co-chair of it, I should say.
Good afternoon, Chief Judge Wilson, Chief Administrative Judge Zayas, Presiding Justices Renwick, LaSalle, Whalen, Justice Clark, and Bar President Lewis. Thank you for the opportunity to allow me to present today on the need for civil legal services, especially in family court. As you all may know, I was elected a family court judge in Albany County in 2014, and I have been serving as the presiding family court, as the supervising, family court judge in the 3rd Judicial District. In 2019, I was designated as an acting Supreme Court justice in this district, and I preside over the integrated domestic violence courts, and we've been expanding them in our district. It is because of those experiences that I'm here sharing my thoughts. But before becoming a judge, I served the families in this area in family court in a variety of capacities. I worked for the Albany Law School Domestic Violence Clinic, representing survivors of domestic violence in family court. I worked for the alternate public defender, representing indigent adults in family court. I also worked as an attorney for the child. As an assistant county attorney, I prosecuted juvenile delinquents, and then finally as a support magistrate, I heard matters involving child support. As you know, in family court, litigants are facing a lot of crucial, it's a crucial time in their lives, and they're facing a lot of crucial issues. You have parents that are battling over custody, battling for more time, battling for the ability to make decisions over their children. You have grandparents that are seeking custody and visitation with their children. In cases of abuse and neglect, where there's a risk of harm to children, parents are facing loss of custody. They're also facing the termination of their parental rights. We have issues of family offenses where partners are coming to court seeking orders of protection because they're facing abuse at home. We have juveniles who are being sent to detention, who are also facing placement up to the age of 21. And in all of these cases, the Family Court Act does provide counsel, and rightfully so, but the Family Court Act does not provide counsel in all matters. Interestingly enough, one of those areas where I believe it's required is in child support matters. The Family Court Act does not allow for the court to assign counsel to indigent litigants who are seeking an order of child support. So when you have a parent that comes to court who wants to establish support, they're not entitled to an attorney. Neither is the respondent. So they're left trying to navigate the court system on their own, providing the magistrate with whatever is needed to make an actual order of support. Parents may not know that they are entitled to, for example, a share or a portion of medical expenses that are unreimbursed, or a portion of the premiums that they have to pay for health insurance. They may not understand that they can seek support for educational needs in college, for example, for college-age children. And on the flip side, the respondent may not be aware that they are able to defend against such expenses, perhaps because they cannot afford it, that they might be able to argue that they have a disability and are not able to provide the court with the information that the magistrate needs in order to assess the actual disability of the respondent so that they can reduce their child support obligation. And so what winds up happening is that you have litigants who are then facing either not enough support for their children or too much support, not able to pay, it's unmanageable, and they wind up being brought before the court again on a violation of support, which can lead to possible jail time for the respondent. And even though the respondent may be entitled to an attorney, the petitioner is not. And that is also a burden, because the one who is actually required to receive the support may not have the ability to prove their case. And maybe there is a willful violation here. Maybe the person has reduced their income intentionally to avoid paying child support, and that litigant may not know how to actually present that evidence. This is where civil legal services from organizations like the Legal Project, which is part of the Capital District Women's Bar Association, and the Legal Aid Society can provide assistance. There were many times when I was a child support magistrate where I had litigants that came and were frustrated because, for example, they did not know how to find the respondent, and they felt that it was the court's responsibility to actually find them. And they would get frustrated. And it didn't matter how much I explained to them that it was not our responsibility. From their perspective, we had all the tools that we needed to find them. They felt we had access to their Social Security, and because of that, we could get their license plate, find out where they are throughout the world, and help them with that process. And they didn't understand that as a petitioner, it was ultimately their responsibility. They were not entitled to counsel. And an organization like Legal Aid would be helpful in those situations because obviously they know what the law is. They can assist with service of process. They can file motions for alternative service, something that an unrepresented litigant would not know how to do. Similarly, in paternity matters, the statute does allow for the court to assign counsel to the respondent, but not to the petitioner, which can create two situations that I think are troublesome. First of all, the petitioner who is trying to establish paternity on the respondent may not be able to defend against an attorney who has been assigned to the respondent and whatever issues they bring up or defenses they might have to the actual petition. I believe that the legislature probably intended or probably was anticipating that the respondent in paternity matters would always be the putative father. But that's not always the case. Often, a putative father is the actual petitioner who is trying to establish paternity over a child that they believe is theirs, and they're facing a challenge from a respondent who is represented by counsel, and they don't know how to defend against it. They wouldn't know how to defend against the issue of estoppel, for example, which could prevent them from going forward, not knowing that they can request a hearing, not knowing what their rights are, not being able to explain why estoppel doesn't apply or defend against it. And these are areas where, again, civil legal services are important because these attorneys know what the law is. They would know how to present the proper evidence to the magistrate or to the court in order to allow us as judges and magistrates to reach the proper conclusion. It's important that we have and continue to have funding, but also expand it so that these services can be provided. Here in the Capital District, we have the Legal Project, but their attorneys represent litigants who are in matters involving domestic violence. So it's not all cases that come before family court. It's important, though, because when they do have a client who's facing domestic violence and they represent them in family court, they represent them in all aspects of the case, whether it's support, custody, family offenses. But if there is no domestic violence component, generally they don't take those clients. And Legal Aid Society can do that, but they don't provide that service currently in family court here in the County of Albany. But certainly those are services where it's important to have the funding, it's important to have the organizations that can provide that service so that litigants can wind up with the proper solution. And I thank you for considering this important issue, for continued funding of these organizations, and for giving me the opportunity to share my thoughts.
Thank you, Judge Rivera. So if you, again, will hold for a question, you can find, or more, you can find plenty of places where Chief Administrative Judge Zayas and I have said that family court is one of our priorities. I've heard the governor say the same thing. I've heard legislators say the same thing. My understanding is there's legislation that's been signed by both houses that is waiting for the governor to add a number of family court judges, but I think our concern has been we need to have lawyers in those family courts, and they need to be properly funded, and particularly as to the institutional providers, I think, as Mr. Flagg was getting at. There doesn't seem to be sort of a comprehensive look at what funding is needed for the institutional providers to be able to sort of carry out the kind of comprehensive representation we're speaking about, or even the representation needed when we add some family court judges. So what is it you think we can do about that?
Well, Chief Judge, it seems that the funding that is needed needs to go to training, to being able to hire more attorneys. Sometimes they don't have enough funds to hire additional attorneys, and also to provide other services like investigators who can help them find people, process servers that they can have access to, the kinds of expenses that are there but that the litigant cannot, him or herself, pay for, that normally a moneyed litigant can. You know, those are the kinds of funding areas where I think that even civil legal services organizations need the funds so that they can fully meet the needs of their clients. I mean, there are other areas that are outside of the civil legal services that I know, Judge Wilson, Chief Wilson, that you are covering that are necessary, but with respect to this particular topic, the type of funding that will allow them to expand the services they provide and also to hire more attorneys, to train those attorneys to deal with the issues facing the litigants in family court in particular, because they may not have attorneys that are familiar with family court work.
Just one, with regard to 18B attorneys and the kind of support that they can provide, do you find that you have the panels with 18B attorneys?
It varies.
And I guess I should ask is, and if not, what can be done to improve that?
So it does vary, Justice Renwick, in that depending on where you are in the state of New York and the counties, some counties could say, yes, we have a good number of attorneys available. Others will say, no, we don't have any. COVID had an impact on that. A lot of attorneys stopped representing litigants that couldn't afford to pay their fees, and some of them left because the reimbursement rate was too low. Certainly the legislature, as you know, increased the reimbursement rate for 18B attorneys throughout the state of New York. It took 20 years for that to happen. The commission, the Williams Commission, suggested that perhaps we have a cost of living adjustment on an annual basis or commensurate with what state employees would receive, and perhaps that would give these attorneys the idea that they don't have to wait another 20 years to have an increase. It's difficult to keep attorneys because they can't just make this a full-time job because they cannot afford that, and so they have to juggle their time with other types of cases. And if the income was there, perhaps they could spend more time on family court matters and not have to find income in other areas of the law. And that requires legislation. But obviously in this particular area, that's where the civil legal services can help, because unless the legislature acts, we have to depend on other ways to provide the service to the litigants. And legal aid and organizations such as that can fill in that gap to a degree.
Good morning, Judge. If I could piggyback off my colleague's question. As you indicated, the legislature for 20 years failed to act, and today we're in this position, though, as a result of that legacy of 20 years. What effect has this had, particularly on communities who do not have English as a first language? In other words, on Long Island, I can tell you, many of my colleagues who are bilingual, with Spanish at least, have left 18B because they couldn't run a practice, because they just couldn't make enough money. Do you see an additional effect on communities who do not have English as a first language as a result of the legislature's disinclination to act for 20 years?
Absolutely. I mean, the effect was already there, but it's gotten worse. In upstate New York, even more so. I've gone out of my way to seek attorneys that I heard were bilingual to see if they would be willing to join our panels, for example, here in Albany County. I remember when I was practicing, I was one of 3 attorneys who was bilingual, and at the time that I became a child support magistrate, one of the other attorneys became a family court judge and took the 3rd attorney to be her counsel. So that removed 3 bilingual attorneys from the panel at the time. And so it's very difficult to get attorneys who are bilingual, period. But certainly the lack of funds to make it something worthwhile did have an impact on that. Increasing that rate has helped, and we've seen some attorneys come back and are now taking cases again. But yes, it has had an impact. I mean, Spanish is the biggest language, but that's not the only one. It's hard finding attorneys in general who are bilingual. That is a service that, again, is needed because you don't need the use of an interpreter if you're able to speak the language. And for those among you who are bilingual or who have another culture, you understand the importance of being with someone that understands you, that gets you, that knows about you without you having to explain it all. So there are a lot of benefits to that, and an increase in the funding and the pay would certainly help to get a lot more attorneys. I mean, I have to say, attorneys in general don't like coming to family court for whatever reason, they shy away from it, and no matter how much money you pay them, they don't want to come. But for those who do, it's important to have the funds there to pay for their service.
Thank you.
Thank you.
Next, we have Matthew Dornauer, who is the Chief Legal Officer of Heineken USA.
Good afternoon. Chief Judge Wilson, presiding Justices LaSalle, Renwick, and Whalen, Justice Clark, Administrative Judge Zayas, State Bar President Lewis. My name is Matthew Dornauer. I'm presenting today on behalf of Heineken USA, based in White Plains, where I'm the Chief Legal Officer. It's my honor and privilege to appear before you today to discuss the vital importance of expanding access to justice to the millions of residents of New York whose legal needs are far too often unmet in our current system. Before I do, however, I'd first like to thank the Chief Judge for holding this hearing today and for his continued leadership and support of civil legal services in the state. Everyone deserves fair and equal access to justice in our country, and more specifically here in New York. This is at the heart of our legal system and the rule of law. Unfortunately, however, that's often not the case. Even with the tremendous work and progress of New York's court system, as well as the civil legal services providers across the state, as Ron mentioned in the Justice Gap study, low-income Americans do not get any or enough help for 92% of the legal problems that they face. That is a startling statistic. The justice gap continues to be a crisis in New York and throughout the country and requires our continued focus and effort to try to close that gap as much as possible. Advocating for fair and equal justice has been an integral part of my legal practice beginning in law school and continues to this day. While at Notre Dame Law School, I witnessed firsthand the crucial importance of providing civil legal aid while representing low-income residents of South Bend, Indiana, through the law school's legal aid and mediation clinics. Our clients could not afford an attorney and needed help navigating our often complex legal system. And this was in order to ensure the protection of some of life's most basic needs related to consumer debt, housing, immigration, and mental health, among many other things. And like the legal services providers here in New York, far too often we had to turn away many potential clients because of limited resources. My commitment to pro bono representation continued as I began my legal career in Chicago at the law firm Sidley Austin, where I gained a deeper appreciation and understanding of the unmet civil legal needs within the city, while representing clients in immigration cases and wrongful termination and discrimination suits. After I became an in-house attorney, I then taught the foundational principles of constitutional law and the Bill of Rights to middle schoolers throughout Chicago Public Schools. And today, I'm in the midst of working with my legal team at Heineken USA to revive our pro bono program. And to that end, we've recently partnered with one of our neighboring civil legal services providers, Legal Services of the Hudson Valley, to assist with their virtual pro bono housing advice clinic, which will involve the support from both attorneys and non-attorneys from our legal team at Heineken. Since the Heineken brand was introduced in the U.S. in 1933, right after Prohibition, New York State's been our home. Our network of 85,000 employees that help us sell our portfolio of over 300 beers and ciders throughout 192 countries in the world. Although we are a global brewer, as evidenced by what I just mentioned, we operate at a very local level here in New York. We are headquartered in White Plains, and our products are delivered, warehoused, and sold in thousands of establishments throughout the state. At Heineken, our focus is on people, which is embodied in our company's purpose, brewing the joy of true togetherness to inspire a better world. This company purpose is predicated upon a strong societal infrastructure, which begins with ensuring people have fair and equal access to justice. In turn, this creates a stable, healthy society and business environment for not only Heineken, but the thousands of other companies throughout the state. As lawyers and business leaders, in-house counsel are uniquely positioned to not only provide civil legal services in our communities, but also to advocate for the additional funding of civil legal services. Last year, a record number of 208 general counsel and chief legal officers, including myself, signed a letter to Congress requesting increased funding for LSC in order to support civil legal aid throughout the country and here in New York. This was the 6th year such a letter was sent to Congress, and I'm confident we can break last year's record number of signatories and hopefully secure increased funding this year. As retiring federal appellate judge David S. Tatel from the D.C. Circuit Court said in a recent interview, quote, "Lawyers have a special obligation because of our legal expertise to ensure the legal system works for everyone. It is imperative that business leaders use their voices to help the significant numbers of low-income New Yorkers who do not have adequate access to civil legal services. Simply put, we can and must do more as a business community. Therefore, I implore my fellow business leaders to advocate for additional funding of these indispensable resources for New York's most vulnerable citizens. With inflation still high, the expiration of COVID-related benefits, and increased demand for civil legal services while staffing constraints persist, now more than ever, we must continue to support increased annual funding for civil legal services. To that end, Heineken USA respectfully requests that the Judiciary Civil Legal Services funding be increased to the maximum amount deemed feasible. In closing, on behalf of Heineken USA, thank you for your continued tireless efforts to close the justice gap and for giving me the opportunity to speak at today's hearing. Thank you.
So, Mr. Dornauer, thank you especially for being here. You're the only person here, I believe, who is not in the public service. You're in private industry. I was in private practice for 30 years or so, and I applaud you and Heineken for your efforts. You know, everybody here, I think, and I can tell from the way you spoke, you feel the same way, that this is a matter of justice and of fairness. But for businesses, I think it's also a matter of economics, that if you have an employee who's having a housing issue or a child custody issue or a credit issue, to the extent that detracts, which it must, from that person's work, from their mental well-being, from things that they have to worry about, it hurts your business. It hurts the businesses of everybody else in this country whose employees routinely have to go through traumas like that. And that when those people are just barely hanging on and can't afford a lawyer, the consequences can be catastrophic for not just them, but for business. So I think it's laudable, but sort of more than that, that you've taken this on and that you've, worked with other businesses and you've gotten them to lobby Congress. And I'm sometimes tagged as a radical. So let me ask you to think about something radical. Perhaps you and however many signatories you can get can make a matching offer to Congress, right? Toss in $1 million apiece if, and only if, Congress increases legal services funding by at least that much money. I think you will benefit from that. I think all businesses will benefit from that if Congress comes through, and if not, shame on them.
Yes, I wholeheartedly agree.
So take that as a challenge.
No, I do. Challenge accepted. Challenge accepted.
Chief, could I ask a question?
I second the challenge. That would be all I would say.
Justice Whalen.
Yes, Mr. Dorn, thank you for Dornauer, thank you very much for your wonderful presentation. I'm curious as to what, if any, steps are taken by in-house private, law firms or corporate law firms, and also maybe your experience with private firms that are also participating and trying to get lawyers in their offices to participate in these activities where they volunteer their time and they help out in housing court and various courts. Has there been some effort to, and I imagine there has been, to encourage these various lawyers to do that so that they don't feel like it's taking time away from their billable hours or their time, their legal product that they're giving to their company, and they're not going to be hamstrung in the advancement within their law firm practice or their corporate in-house practice, because I think that by doing that structurally and allowing these young lawyers to know that by giving their time to these efforts, it's valued time. I think you'd probably encourage more participation, and what a generous thing it is for corporations to do that very thing. In other words, to encourage them to do that in a real meaningful way. So I'd like your thoughts on that, and do you see that happening? Thank you.
Absolutely. Yes, I do see it happening, although I think at the in-house level, there could be a bit more, but it depends on the company. Some companies have very robust, built-out, wonderful pro bono programs. Ours, I'm trying to revive it right now. And I think, to your point about having support for it, and especially for us where we don't have billable hours, it really starts at the top. It starts not just with me, it starts with our CEO. And our CEO, Maggie Tammany, is very much on board and fully supportive of our efforts. And I think at other companies, if they don't have programs or they would like to have their programs be a little bit more supported, perhaps they could seek out the assistance of their fellow C-suite members, their CEOs in particular, and ask them to be advocates for it as well. I think with respect to the law firm, and it's been a little bit since I've been at one, I was at Sidley Austin for a little while, as I mentioned. I think firms do a nice job of allowing pro bono to count towards billables, which of course helps incentivize that. However, could they be doing more? Yes, absolutely. They could be. I think there's maybe not an easy answer, an easy fix for that, but I think it's just, again, having partners, having, chairs of the firm really, highlighting the importance of this. I think that can't be stressed enough.
Thank you, Chief.
Before I let you go, it occurred to me that exactly a month ago today, I was sitting on the banks of the Amstel River with a couple of Heinekens.
Oh, I love that. Wonderful. I love hearing that.
Thank you, Mr. Dornauer.
Thank you very much.
Next, we have the Honorable Fern Fisher.
Good afternoon, Chief Judge Wilson, Chief Administrative Judge Zayas, Presiding Justices Renwick, LaSalle, Whalen, and Clark, and Bar President Lewis. I am honored to have the opportunity to speak to you today about the housing crisis in our state and changes and reforms that the court system can make to address the crisis. I have spent all of my legal career, 45 years, enmeshed in housing law issues. I started as an attorney representing low-income tenants, and I was a New York City Housing Court judge. For years, I was the court administrator in charge of the housing parts of the New York City Civil Court for over 21 years. I authored the views from the bench for residential landlord-tenant law in New York, and I was the director of the New York State Court's Access to Justice program. I am currently a visiting law professor at the Maurice A. Dean School of Law at Hofstra University, where I teach housing-related classes, and I am the executive director of Legal Hand, Inc., where we assist unrepresented litigants with their housing and other matters in 3 regions of the state. Based on my extensive experience, I am told that I'm recognized as a housing expert. But more importantly, and on a personal level, I am the daughter of a single-parent mother who lost our home to foreclosure, a fact that I learned on the day that I graduated from Harvard Law School. You know, the unforgettable words from Dorothy from Wizard of the Oz, "There's no place like home," comes to mind. But for many New Yorkers, maintaining or acquiring a home is elusive. Having a home is a fundamental human need. The absence of a stable home starts the spiraling down into other social service and legal problems that are difficult to recover from. Lives are forever changed. People and communities of color are most affected by evictions. In my nearly 45 years as an attorney and a judge, I fully believe that we are in the worst housing crisis ever. That crisis is being experienced throughout the state. Every region in the state is affected in various ways by this housing crisis. Rural New York has experienced the sharpest increase in eviction rates. 40 counties upstate have eviction rates that have surpassed pre-pandemic rates. The full impact of eviction upstate cannot be fully assessed due to the lack of data from town and village courts. Manufactured homes can provide affordable housing and make up 10.3% of the housing stock in rural New York. And these manufactured homes are dwindling due in part in closing of places where the homes are placed, and the inability of homeowners to purchase the land where their homes are located on. In Nassau and Suffolk, between 19 and 26% of residents are in structural poverty. The rental desert in Long Island has created housing shortages, and economic strife has increased evictions. In Westchester, rents are the second highest in the state and are impacting the poor. In Buffalo, filings are outpacing pre-pandemic numbers. In New York City, rent stabilization rent increases and 20 to 30% increases in non-regulated housing will push many individuals over the edge. This crisis is created by a perfect storm. A perfect storm of factors including increased poverty due to a bad economy and COVID, an aging population, increased mental illness, a growing immigrant population with language and documentation challenges, lack of affordable housing, complex substantive and procedural housing laws, insufficient funding for legal assistance, and lack of training of judges and court personnel, and slow implementation of court reform. I want to note that housing law is complex and multi-layered. Real property law, real property actions and proceedings law, civil practice laws and rules, multiple dwelling law, general business law, housing maintenance codes, housing discrimination laws, fair housing laws, laws affecting manufacturing homes, and other local, state, and federal laws may apply depending on the type of housing involved and where the housing is located. It takes years to develop an expertise in housing law. Attorneys who don't specialize in landlord and tenant law find the area complicated and the courts that handle the cases daunting. You cannot hand over a housing case to an inexperienced, unsupervised pro bono attorney. Unrepresented litigants are in a worse position. Tenants often can't identify the type of housing they live in to determine what laws affect them. They are totally unable to identify substantive and procedural defenses Unrepresented litigants settle their cases often with unfair terms that do not account for defenses, or they're forced to trial. During trials, they have no knowledge of trial procedures or rules of evidence. Unrepresented litigants are unable to complete court forms, make motions to have their cases dismissed, and obtain subpoenas to obtain evidence. They are on a playing field without the rules or the appropriate resources. Keeping tenants in their homes is essential to prevent homelessness. Eviction in most cases will result in an individual having to pay a higher rent and possible relocation to a different community. Evictions are traumatic and destabilize families. Communities are affected when there are high rates of evictions and homelessness. Gentrification is an unfortunate outcome when there are high rates of eviction. Preventing unwarranted evictions must be a societal goal, or we risk having a state where low-income persons have no place to call home. But there are things that the courts can do about this. So I start off with talking about support for legislative changes. We've heard already that we need more money for legal representation. Increasing legal representation will address much of the inequities faced by those being evicted, but will not solve the problems of all litigants who will face evictions. In a perfect world, all low-income persons would receive full representation in eviction cases. We are far, far from that perfect world for low-income persons in most parts of the state. Access to counsel is particularly acute in rural areas. And please note Russell Weaver's written testimony. Russell is the research director of Cornell University ILR School, Buffalo CoLab. He indicates that in 11 counties where eviction rates are extremely high, there is also an undersupply of legal assistance. No surprise here. Additional funding must be devoted to eviction for low-income individuals until 100% are served. We are unlikely to reach the 100% mark in the near future. Until 100% funding is obtained, many low-income individuals will continue to be unable to obtain a lawyer. The court must provide access to justice in eviction cases to all litigants unable to obtain lawyers. And the court must look at all avenues of legal assistance from full or unbundled representation to providing targeted legal information and helping filling out forms to accomplish full fairness. Good cause legislation is also important. Preventing evictions is not simply limited to allocating dollars towards paying rent, as many evictions are not based on the non-payment of rent. Currently, when a tenant does not have a lease and lives in an unregulated premises, the owner does not have to provide a reason for seeking eviction. The number of persons living in unregulated apartments throughout the state who do not have leases is massive. The numbers of evictions could be decreased with the passage of legislation that would require owners to establish good cause before an eviction is approved by the court. The court's support for legislation requiring good cause might assist in making it a reality. Good cause requirements will make a big difference in the volume of cases filed and the evictions that result. In New York City, judges are able statutorily to order an owner to make repairs and correct housing violations within a non-payment or a holdover case. In other parts of the state, judges can't order the repair or removal of a violation. The judge is limited to giving an abatement of the rent. In New York City, tenants can also commence a simple and low-cost proceeding to compel the correction of housing violations. Litigants living in substandard housing in most jurisdictions outside of New York City must rely on their city, town, or village to act in order to obtain a habitable home. Depending on the location, there is mixed success. Too often, the locality issues a vacate order rather than compel an owner to make repairs. A New York Supreme Court case could be commenced, but most New Yorkers do not have the ability to do so. Faced with dangerous conditions, many are forced to leave their homes due to a lack of a simple, low-cost, and effective enforcement mechanisms. Those that leave their homes may end up in more expensive houses in a different community or in a homeless shelter. Allowing judges to handle repairs and violations within cases started by owners is effective. Also allowing tenants to commence an action solely to obtain a habitable home in the lower courts would also be effective. Court rule changes and new legislation will be required to make these changes, and the court's support for change would pave the way. Access to justice in a unified state should be the same from jurisdiction to jurisdiction. There should not be more justice in one part of the state, but less in another. Unfortunately, New York is less than uniform. Examples of the lack of uniformity are offered in these remarks, but are not intended to be exhaustive. It is suggested that a study be completed that examines completely disparities and best practices. In the interest of time, because I've been warned, I will only remark on some of the problems, and please refer to my written remarks for a full explanation. So in New York City, oral answers of tenants in non-payment cases are recorded on a triplicate form listing most of the common defenses. The tenant gets a copy, the owner gets a copy, or the owner's attorney gets a copy, and then of course, the court has a copy. This form serves more than one purpose. First, the tenant can look at the form to see what defenses can be raised in a non-payment cases. It's the first time they've ever seen the defenses. Most tenants have no idea what can be raised as a defense. The owner has written notice of the defenses that the tenant is raising, so the owner can prepare better. The judge obtains notice of what defenses the tenant is raising. A recorded answer allows the judge to determine if a settlement agreement addresses those defenses. And at a trial, the judge would know in advance what the tenant is raising as a defense and be able to ensure a hearing and disposition on those defenses. If there is an appeal after trial, the appellate court has a record of the answer that was interposed when reviewing if a tenant had the opportunity to have defenses properly heard. In most jurisdictions, there is no record of an answer by a tenant, either on a form, endorsed on the file, recorded by tape, or by a court reporter. It is also noted that in holdovers, there is no answer by tenant, no place in the state, not even in New York City. Service of orders to show cause by unrepresented litigants. All right, in New York City, unrepresented litigants are permitted to serve orders to show cause, papers to stop an eviction themselves, on opposing lawyers and parties, and on the city marshal. This practice has existed for over 40 years. An informal survey conducted by a Hofstra Law School student showed that in some parts of the state, the New York City practice is followed, but that in other parts of the state, it is not. The CPLR provides that a judge can grant permission for the litigant to serve an OSC themselves. Court publications and information sheets distributed by various jurisdictions indicate that a litigant can't serve papers without reference to the judge being able to grant permission to do so. Various clerks' offices tell litigants they can't serve the OSC themselves on opposing counsel and on the marshal or the sheriff. For many litigants, having to get someone else to serve an OSC is a hardship or an impossibility. Elderly persons often are isolated and have no friends or family to serve papers for them, and for some, the embarrassment of being evicted stops them from asking someone they know to serve the OSC. Hiring a process server to serve an OSC is not feasible for most people being evicted. At a minimum, litigants should be made aware that they can ask the judge for permission to serve the papers themselves, and judges and clerks should be educated on this possibility. Let the judge decide. I am not going to speak extensively on notice to quit and notices to terminate because of time limitation, but the practice varies from all over the state whether a notice to quit or a notice to termination has to be just given or served. It should be the same throughout the state. The law is the law. Let's make sure that there is uniformity. The court website and a court publication do not indicate that a notice to quit must be served. And so the court website needs to be very clear and updated. Programs for appointments of guardians ad litem. CPLR Section 1202 provides for the appointment of a guardian ad litem in all cases, including housing cases, when a litigant is incapable of adequately protecting their rights. CPLR 1203 prevents the entry of a default judgment until a guardian is appointed. A judge can appoint a guardian sua sponte, but throughout the state, judges are failing to appoint guardians for some of our most vulnerable citizens. New York City has a court-based guardian ad litem program in the housing court, which has been running for quite a long time, and guardians are appointed regularly. The Westchester courts recently launched a court-based program. There are no other programs actually available in the state. Steps must be taken to remedy this potentially harmful deficiency in complying with the CPLR, which impacts the elderly and persons with mental and other disabilities. In fact, today's news, when I watched this morning, indicated that 1 in 5 persons are suffering from mental illness. It's a large number of people. Court programs for the vulnerable must be available throughout the state. No matter where vulnerable citizens live, they should have equal access to services. All right, statewide resources, and some of it, again, I'm going to, sort of cut through. Court users are from diverse populations, as Judge LaSalle has mentioned, and can have reading levels as low as 5th grade. This requires that there be a robust number of plain language forms and instructions in many languages. New York lags in this effort. And the challenge is Massachusetts has forms in 8 different languages. More DIY and other form programs, DIY, do-it-yourself programs, have been providing greater access to justice for unrepresented litigants, but there aren't enough. More should be created in housing, such as an illegal eviction program, an HP action program, an answer to a non-payment case program, which is usable by all tenants. Thinking out of the box for the future. And I know this is the future, but we have to think ahead. Computer programs could be developed that will allow a person to answer in their primary language, but the court form is printed out in English. A program of this nature would be a major leap in access to justice for diverse populations. Updating and maintaining the content on the website is crucial, that it would be current and accurate and very clear for people to use. And this is, the next topic is extremely important. As mentioned previously, judges outside of New York City and Westchester have no programs to assist them in appointing guardian ad litem's. And this difference between the jurisdictions must be remedied. CPLR 1203 requires that before default judgment can be entered against a person who is incapable of defending or pursuing a claim, a guardian ad litem must be appointed. And judges are likely not to be on notice that a litigant requires a guardian if there's a default in appearance. How would the judge know? The programs currently in New York City and Westchester can't remedy this problem. Court administration must act to come up with a remedy. The Commission has proposed that a statewide requirement be put in place that an owner must, upon applying for a default judgment, submit a sworn affidavit indicating to the best of the affiant's knowledge the respondent is not elderly, disabled, or suffering from mental illness. And we ask that action be taken on this proposal as soon as possible. Yes or no? Just action. Judicial and non-judicial education. I have experienced since I retired, firsthand, court clerks providing inaccurate legal information and incorrect court forms to litigants in housing cases. I have also become aware of outcomes in cases decided by judges in violation of law. And this is particularly a problem in the town and village justice courts. Housing law changes frequently, requiring continued education on developments, and continued education on housing law for both judges and court clerks is essential to avoid unjust outcomes. Sustained education on dealing with unrepresented litigants and impoverished diverse populations will also expand access to justice in housing. And as I mentioned, there's a mixed success in collecting data from town and village justice courts, so we really don't know the full extent of the eviction crisis upstate. And so steps must be considered by the court to work with the state legislature and localities to cure the problem. We can't do it ourselves. We have to have partners. Conclusion, a quote from William Bennett states, "Home is a shelter from storms, all sorts of storms. Many New Yorkers are caught in a massive storm without stable shelter due to poverty aggravated by COVID and a challenged economy. Too many families have already lost their homes or are about to be evicted. The court system has a moral and a legal obligation to ensure that only evictions that proceed are ones that are warranted. Some of what has to be done to stop unneeded evictions require money and legislative changes. The court cannot control the state budget or pass legislation, but it can have influence. Other avenues of change do not require substantial money or outside assistance. The court must review and assess what it can do to ensure New Yorkers have a home by using innovation and resolve. With so many New Yorkers on an economic precipice, the time is now for action.
Thank you, Judge Fisher. So 2 observations and a question. First observation is there are a lot of things that in your testimony that I think we can start tackling. So I thank you for that, and I hope we can count on your continued help as we work through those many suggestions, because they all sound pretty good.
No one's letting me retire, Judge.
Good. Second is, Judge Zayas and I and others have been meeting about housing almost incessantly over the last many months with all kinds of different people, landlord groups, tenant coalitions, varieties of others. And if you're free tomorrow at 4, we're meeting with about 30 housing court judges from New York City. You're welcome to attend. It'll be at Beaver Street.
I will try. Those are my people.
Excellent. And then the third is, taking into account everything you said, there seems to me, though, a mismatch in some of the things I've read, which is that, and one I mentioned, 14% of the people in the state live below twice the federal poverty level, which is very low. I mean, maybe for in a very rural place, you can just get by on that, but in a metropolitan area, there's no way you can, not
Long
even
Island.
Buffalo. Yeah, right, or suburban even. And then there's just not a sufficient supply of housing. Anything the courts can do about that?
Yes, to preserve the housing that we can preserve and making sure people don't get evicted, in cases where they shouldn't be evicted, so they can stay in their affordable housing.
Yes.
That's one.
But we still seem to have a fundamental problem that there just isn't enough housing and it's too expensive and there are too many poor people.
No, and that requires, some real resolve from the state legislature and local, legislators to stop listening to the voices that don't want low-income and moderate-income people in their, or undocumented aliens, undocumented people in their neighborhoods. Too many voices, too much negativity. So affordable housing is crucial. The government needs to develop more affordable housing. But as a court and as judges, the only thing that we can do is preserve the affordable housing that we have, because some affordable housing goes away after people get evicted. So if they don't get evicted, and there's a reason to not evict them, they should be able to stay in their homes.
Chief, can I ask?
John?
So, good to see you, Judge Fisher. After Mr. Donauer spoke, I wrote down that perhaps we should try to get some law firms to get involved in taking pro bono cases, in the housing court in particular. And then you got up and said that because of the enormous complexity of these cases, that they're not necessarily the types of cases that pro bono attorneys from law firms should be assigned to. And so I'm wondering, is there any fix for that? Because it seems like,
We can still use them, Judge.
I mean, like, for example, can there be extensive training for the pro bono lawyers from the firms? It does seem that there's a great need in housing court, and the firms want to do things. And I just wonder if there's a fix for that.
Yeah, well, some firms won't do landlord-tenant because of conflict of interest, but those that will do it, there's always a way of using a pro bono attorney. They could give out legal information. They could do, the intake, to get the information. In parts of the state, we actually need impact litigation because things need to change either from, a state agency or whatever. And we don't have that outside the city of New York. Legal Aid's done a wonderful job with shelter and, New York City Housing Authority, Section 8, but we don't have that litigation outside the city of New York. When I moved my career back to Nassau, Suffolk, I was in total shock. And so law firms can certainly do that work. Legal services programs can't, for various reasons, but they don't have the resources, so they can do that. They can do the simple, we have to learn to triage so that the really simple cases can be done by pro bono attorneys, and the more severe cases can be done by legal services, legal aid attorneys, or even law students. As you know, I use law students to provide legal information, and it is successful. So I think we have to learn to triage. I think we need more of a library of training, on videotape that, law firms can use, and we don't have to repeat the trainings over and over again. But part of the problem with using pro bono attorneys is that they're not necessarily aware of the problems that impoverished people have. And so, they're either insensitive or they're in total shock, and they don't know how to deal with it. And in our courts, it's tough. It's like family court, you gotta, put your boots on and get into the trenches. And so sometimes pro bono attorneys are not appropriate for that, but I do think there is a role. I am not by any extent, counsel, saying that we should not use attorneys from law firms and from corporations. We just have to use them wisely.
Judge, if I may, Judge.
Yes, Judge.
Obviously, your expertise is well-renowned throughout the state on these issues. But you touched on something before that has an effect when you talk about the housing crisis, right? When we talk about gentrification, and it's a dirty little secret that for some reason we don't want to talk about in this state. Oftentimes, the working poor and the working class are pushed out of communities which they've been in for generations as elites move in. The dirty little secret is the elites who move in tend to be white, and the people being pushed out tend to be people of color.
Exactly.
For some reason, that discussion, members of our legislature don't want to talk about it, municipal government doesn't want to talk about it. I see you smiling, so I think you agree.
Stop me from talking about it.
Well, no, I know that. And that's why I'm going to ask you this question. To what extent can our state legislature, they might be disinclined to do it, but to what extent could our state legislature, our city councils, our municipal governments around the state work to protect the working poor from being pushed out of their homes by the elite and their upwardly rising children?
Sure. Higher Department of Social Services rental amounts, because it's paltry what they actually give people for rent. There is no rent in a city, suburb, or rural that actually is around the amount that DSS gives, particularly for a family. So that's one thing that they can do. Good cause eviction, so somebody just can't on a whim decide to evict somebody. And I will give the legislature credit because they changed the law in 2019 to create more notice before a month-to-month tenant can be evicted, so it's 30, 60, or 90 days. But still, if you get evicted at 90 days, you have no place to go. You have no place to go. So in your playing field, Judge, I just heard that in West Hampton, for example, there is absolutely no place for workers to live. So they can't live on the east end, so they're moving actually west to more affordable places like Coram or whatever.
But also,
And they have to commute.
and also, as you know, it's also part of the second department, Bushwick, Bed-Stuy,
Yes.
Astoria, Long Island
Everybody's
City.
getting pushed
So it's not just, Long Island certainly it's an issue too, but it just seems to be an issue. Again, and I appreciate your input on that topic. Thank you.
Thank you, Judge Fischer.
Thank you.
And next and finally, before the break, she's had to wait a very long time, but Dee Dee Hill.
Good afternoon. Thank you to Chief Judge Wilson and to all the members of the distinguished panel and to the Permanent Commission on Access to Justice for holding this hearing and for providing me the opportunity to give remarks on behalf of the Schuyler Center for Analysis and Advocacy. As was noted, I am Policy Director at the Schuyler Center. I sometimes refer to myself as a recovering lawyer, but in fact, and that's only because I'm not currently practicing, in fact, I'm deeply proud of the many years that I practiced as a labor lawyer and as an assistant solicitor general for the great state of New York, and just really thrilled to be here today. The Schuyler Center is a 151-year-old statewide nonprofit organization dedicated to advancing public policies that strengthen New York families before they experience crises and trauma, and prevent families from enduring hardships like ill health, economic insecurity, child welfare involvement, or encounters with juvenile justice. Among Schuyler Center's proudest achievements is playing a role in securing the enactment of the early 2022 New York State, or the enactment occurred early in 2022 of the New York State Child Poverty Reduction Act. And this committed New York State to cutting child poverty in half in a decade. This historic effort is an opportunity for New York State to act boldly to once and for all turn the tide on child poverty in our state. I will focus my remarks today on two important ways in which access to civil legal services can play a critical role in ensuring New York meets its commitment to the 700,000 New York children living in poverty, and that represents more than 18% of the state's children. And as Judge Wilson has mentioned several times, our poverty levels don't even get to the number of children who experience real deprivation every day of their lives. It's more like at 200% of the federal poverty level, and so we're talking about more like 40% of our children who really deal with hardship day in and day out. So I am going to focus on how civil legal services can help to ensure that these children and their families can access the services and resources they need and deserve to shield them from the tremendous harm experiences of poverty can cause. First, New York must ensure New Yorkers are able to access the essential social services for which they are eligible by making civil legal services readily available to those wrongly denied or delayed access to social services benefits. The importance of timely access to civil legal services for families facing barriers to accessing benefits cannot be overstated. Typical families that are low income have on average a savings of about $600. So this leaves many families one denied benefit away from a tragedy. Delayed or denied public assistance or heating assistance or SNAP food assistance or child care assistance. This can have a cascading effect, leaving a family scrambling to make up for the lost resources by skipping a car repair, which can lead to missed days at work, which can lead to job loss, or they might skip a rent check, which can lead to homelessness. So this unraveling can happen quickly with devastating and long-lasting impacts, particularly for children. One key solution, the one we've heard over and over again, we need more funding for civil legal services. New York's shortage has been considered at crisis levels for decades. I don't need to tell any of you that adequately funding legal services would not only prevent New York families from the trauma and hardship benefits denials often cause, it would also result in cost savings to the state by saving money in the many other systems that then need to pick up the pieces. A second way in which access to civil legal services can play an essential role in strengthening New York families, particularly those experiencing poverty, is to ensure New York families that become involved with the child welfare system can access civil legal services from first contact with child welfare. Too many New York families, disproportionately Black and brown families, are swept up in the child welfare system simply because they are poor. Timely access to civil legal services can prevent unnecessary and traumatic family separations and ensure families that encounter child welfare gain access to the services they need to thrive as a family. The stakes are too high, the rules associated with child welfare too complex to deny families representation from the start. Currently, New York families do not have a right to counsel until Child Protective Services files a petition and parents have to appear in court. This means that most low-income families are left to navigate critical interactions with the Child Protective Services caseworker investigating them completely on their own. During this period of investigation, families are often subject to home visits, to investigative interviews of parents and their children, and they may be required to participate in preventive services. Notably, the information that is being collected can later be used in making the extraordinary decision to remove a child from their family. All of this happens before most parents are even made aware of their eligibility for legal representation. Here again, a key policy solution is to increase funding for legal services so families that encounter child welfare can access those services at first contact to better ensure families are connected with the services that they truly need and to prevent unnecessary family separations. New York should also require Child Protective Services workers to notify families of their rights in a child welfare investigation, including the right to counsel at first contact. That is not the law now. That should change. In closing, robust legal representation is a necessary part of New York's implementation of the Child Poverty Reduction Act's commitment to cutting child poverty in half by 2032 and to moving New York toward what really should be our goal, which is ensuring that all of the state's children have the resources they need to thrive. And if I can take a moment, I'd love to address a question that Judge Wilson posed to Mr. Flagg about how we might lessen the need for civil legal services. And I think an additional suggestion that I would offer is we need to really take aim at the complex and often punishing barriers that New Yorkers face to accessing essential services, particularly services that are means tested, which are nearly all of them. So things like SNAP food assistance, childcare, affordable housing, all of these services generally require families to fill out really onerous and complex paperwork, often not in their native language. They also confront too frequent authorizations, reauthorizations, so that leads to churn, to families falling off, even when they're still fully eligible. And then, and also these cause long delays. So often, even if a family can hang on, the service comes too late, and the cascading impacts have started. So there will also always be the need for civil legal services because mistakes happen, and families need someone in their corner. But I think one way that we can really head things off is to streamline the benefits process. And I'd note that New York has made some small steps in that direction in a number of areas, but there's a lot more to be done.
Thank you.
Thank you.
I wonder if you think that the benefits area is an easier area, for example, young lawyers at large firms to help than maybe housing court is?
So I cannot speak from experience, having never practiced in housing court. Actually, I represented myself as a law student, and I did win. It was my first win. Yeah, I mean, I think in some of the administrative proceedings, for sure, there's a little more flexibility with rules of evidence and the like. And so, yeah, I think with proper mentorship, that could be a great way for more junior attorneys to cut their teeth. But at the same time, we can't underestimate how critical these services are. So we we refer to them as, they don't have the criminal implications. No one's going to go to jail, but the impacts are so extraordinary that they're going to need a lot of guidance and support.
Thank you.
May I,
Louis, yes.
May I, Judge? So first of all, thank you and thanks to all of the panel. And it sounds to me that one of the general themes here is we need more representation and we need more lawyers. and Mr. Flagg talked about the legal desert. So is there anything being done to incentivize attorneys to get into that legal desert to help these underrepresented people or unrepresented people? I know that 18B rates have increased. I know that law firms and private industry are taking steps to try to provide counsel, but it seems to me that in these areas, we need to have attorneys that have their boots on the ground. And I'm wondering, is anything happening, or do you have any suggestions how things can happen to get people, get lawyers, young lawyers, into these areas?
I mean, I think the very simple answer is we need to raise rates, the rates that are paid to lawyers, and we need to get ahead of the student debt problem too. I mean, none of our attorneys, new attorneys emerging from law school, very few of them are emerging without debt, and most are emerging with really, really significant debt. It's simply impossible for them to enter this field, no matter how much their hearts want them to follow that passion.
Thank you, Ms. Hill. We're going to recess until 3 o'clock, when we'll resume the second part of the program. Okay, we are back for the afternoon portion of the program, and I recognize the familiar face of Neil Steinkamp on the screen there. Welcome, Neil.
Thank you. It's great to be here.
And you're on.
Chief Judge Wilson and distinguished panelists, it's an honor for me to have the opportunity to provide this report for your consideration and these remarks for your consideration. My name, as Chief Judge Wilson just mentioned, is Neil Steinkamp. I'm Managing Director at Stout, where I lead the firm's transformative change practice and our pro bono practice, and have served for several years as consultant to the Permanent Commission on Access to Justice. I offer these remarks regarding the Commission's efforts to develop a realistic estimate of the funding and resources that may be necessary to close the justice gap in New York. By way of background, in 2021, 14% of New York residents were living below the federal poverty level, a full percentage point higher than the national average, with pockets of poverty in the state and among certain populations that are considerably greater than that. In October of 2022, 47% of New Yorkers had difficulty paying for household expenses. It's been well documented that poverty is causal to other crises, including poor educational attainment, housing instability and eviction, justice system involvement, both civil and criminal, health disparities, unemployment and underemployment, community instability, and social safety net resource usage. The effects of poverty often reflected in civil cases involving the essentials of life brought in state courts. In January of 2022, at the request of former Chief Judge Janet DiFiore, the New York State Permanent Commission on Access to Justice, through its funding working group, began to develop a realistic estimate of the funding and resources that could be required to close the justice gap in New York. This estimate was to focus on matters involving the essentials of life for individuals and households at or below 200% of the federal poverty guideline, and to include the various forms of effective assistance that a litigant may require based on their individual circumstances. The working group determined that to develop an estimate of the funding necessary to close the justice gap, it would need separate estimates for each of the matter types that would be considered. The working group, relying on data provided by OCA regarding the number of cases for each matter type, selected several types to assess in successive phases of its work. For each matter type, the working group would conduct a preliminary discussion amongst itself and its members. It would identify key stakeholders to learn from, conduct research as appropriate, further expand stakeholder connections, and then use the information that it collected to create a preliminary budget model for each matter type. Those matter types, the ones the funding working group analyzed, were consumer credit, eviction, both inside New York City and outside New York City, child support, disability benefits assistance, guardianship, contested matrimonial cases, foreclosure, paternity, family offense matters not involving intimate partner violence, and custody matters for kinship caregivers. Collectively, these matters represent about 50% of the total civil case docket in New York, with the remaining 50% being related to case types that don't involve the essentials of life or that already have a right to representation. Those represent about 540,000 civil case filings in New York for the 12 months ended March 31, 2023. For many of these case types, the percentage of respondents or petitioners, depending on the case type, who have legal representation in recent years has been at or less than 5%. The funding estimate also includes the cost of providing effective assistance for persons involved in administrative fair hearings and other matters involving income maintenance and access to public benefits. To provide a comprehensive estimate of the program costs, the funding working group considered a variety of forms of assistance that can provide access to justice. These included full and limited scope representation by attorneys, pro bono lawyers, law school clinics, pre-filing diversion programs, assistance from trained and supervised non-lawyers, mediation and other forms of ADR, community-based resources such as Legal Hand and community dispute resolution centers, and the ways in technology may be able to be assistance, such as guided interviews, online automated forms, e-filing, and other technology innovations. Evaluating multiple solutions was key to estimating the cost based on the spectrum of expected needs of eligible litigants. Funding working group also considered a number of other factors that could affect the funding necessary to close the justice gap, including the potential ways in which court reforms could be implemented over time and could impact the number of case filings or the process by which those filings are adjudicated, the ways in which courts and litigants will respond if there was a significant increase in community outreach and access to effective assistance, and the manner in which Legal Hand and community dispute resolution centers and other forms of underutilized effective assistance could be engaged to assist in closing the justice gap in New York. The provision of additional funding and the expansion or development of legal services programs to deliver additional services, particularly of this scope, of the scope contemplated by this kind of analysis, would necessarily require significant strategic development and an appropriate time period over which such programs could be implemented. The courts, legal services organizations, community-based organizations, and other stakeholders would need to be engaged to develop the appropriate initial strategies for the expansion of services and the means of continual iterative evaluation that would be necessary to assess how the civil legal aid landscape would change based on the availability of these resources, implemented reforms, and other factors. Based on all of that, the funding working group of the commission estimates that between $842 million and $1 billion is a realistic estimate of the additional annual funding necessary at full implementation to close the justice gap for low-income New Yorkers involved in civil legal aid matters, civil legal matters impacting the essentials of life. JCLS funding has provided $100 million annually since 2016, with the addition of recent COLA increases bringing that total to $116 million. The funding working group proposes an initial 5-year goal of adding $100 million to the currently planned JCLS funding and proposes reaching that goal with incremental increases beginning in the upcoming fiscal year, starting April 1, 2024. The working group recommends that additional funding be administered in the same manner as the current JCLS funding, which enables local legal services organizations to respond to the unique local needs of their community in the manner most effective for their organization and their community. The full report of the funding working group will be included in the Permanent Commission's annual report to the Chief Judge later this year. And I want to thank you for your time and your consideration and welcome any questions or comments you may have.
Thank you, Neil. I do have two questions, I guess. One is, and President Lewis alluded to this, there are areas in New York State where there simply aren't lawyers. And so, at least superficially, you could have a whole lot of money and still not have any lawyers there. And so that's probably part of what you were referring to when you said strategic. But money alone isn't going to solve that problem, I think. And you might want to address that briefly. Why don't you try that first?
Thank you, Chief Judge Wilson. So it's a fantastic question, and the issues of the rural justice gap are significant and complicated and very challenging. And I certainly think that to the extent that additional funding were available, engaging both with the rural communities, urban communities, and everything in between is going to be essential, because it's not a one-size-fits-all sort of solution. In those rural communities, it may be helpful to be leveraging resources that are available in those communities, whether it be the courts, the public libraries, any community dispute resolution centers that may be available in rural counties. But I also appreciate your point that there are, simply from a labor perspective, there may not be people, humans available to assist in those communities that are sufficiently skilled and have the experience and expertise necessary. In those situations, it may be helpful to explore technology solutions, either through a remote connection or other means of trying to provide assistance in those situations. But I certainly don't have the solution to the rural access to justice gap as I sit here today, but I do agree that we would need to be mindful of developing unique solutions in those situations, and I think engaging with those local stakeholders would be essential to do that.
And the other thing I was going to ask you to talk about just briefly is my understanding from reading a bunch of things is that investment in civil legal services has a net positive return on investment. And I think you probably know some of that better than I do, and if you might mention that, I think that could be helpful.
Yes, thank you. Also a great question and comment. Many studies, both in New York and around the country, have found that investing in civil legal services has a positive return on investment. The work of the Permanent Commission has found that in New York, the return on investment is approximately $10 for every dollar invested in civil legal aid. And similar assessments have been done by other permanent commissions and by other groups around the country. It varies by case type and by the sort of mode of intervention and type of services that are provided in the different circumstances, of course, as you would expect. But the premise behind that is that by providing those sorts of resources, we're avoiding the crises that occur when people aren't able to access assistance through the civil legal process. And those crises then often require the response of a social safety net, of some form of assistance by city, local, state, federal government to help people in need. So it's a matter of avoiding those crises so that we're not having to pay for those crises and the services that are required after the fact. Services such as homelessness response and the impact to the healthcare system and the education system and many other impacts that individuals and families will have. It has been shown over and over again that it's far less expensive to pay for the assistance needed in those moments than to pay for the crises and the assisted services after the fact.
Thank you. Thank you very much.
Chief, could I ask one question?
Of course.
Yeah. Thank you very much, Mr. Steinkamp, for appearing here today. If I'm understanding your remarks correctly, and maybe I'm not, but maybe you could clarify for me. The study is based primarily upon filings within the court system, and you're analyzing those, and that's where the need is coming from, and that's where the projected budget's coming from. In your experience, though, in the things that you've studied, and I know they've been in depth and broad, what do we know about the need that's out there, the people needing justice that aren't getting to the justice system, that aren't making those filings? Though, I mean, you just touched upon it momentarily a few minutes ago, where you said when they don't do that, they fall into, and we hope to have a safety net that takes care of them, and there's a cost to that, and I understand that. But what do we know about the size of that group of people, and what can we do by way of outreach to bring them into the justice system so they're getting their cases attended to and the services that they need so they don't fall into the safety net?
Yeah, this is a great question. I really appreciate it. We need to know more about that group. I think there has been some great research done and some great study done on this topic of the need beyond the case filings. Rebecca Sandifer has done some tremendous work here, and others around the country has done some really phenomenal work to try to understand legal needs, not just case filings. The working group's focus on case filings was intended to be an initial step. It was a population that could be defined and for which we could create some of the measurements I've just described, and often are going to reflect those moments where crisis, you're right at the moment of crisis when you can provide that assistance. And so it's hopeful that it sort of forms a foundation, but I think to your point, does not reflect the full scope of the need for more than one reason, not just the one that you mentioned, but also because the work of the working group was limited to both matters involving the essentials of life, but also for people at 200% of the federal poverty level and below. And that last criteria, of course, is an important one because there are many people who are above 200% of the federal poverty level that would still not be able to afford or access a lawyer. And so, of course, there's additional need there. But with respect to your point, as I sit here now, I can't tell you quantifiably what the scope of that additional need is, but surely there are a great many instances in which people are experiencing legal needs that have not and likely will not materialize into case filing. And for each of the matter types I mentioned, there would be those circumstances, those what are sometimes referred to sort of upstream legal needs or justice issues that exist. And so, yes, absolutely, we need to be thinking about those as well. I think there are interesting opportunities to be thinking about prevention efforts, and you mentioned outreach as well. I think informing both local outreach efforts and coordinated statewide outreach efforts are going to be essential regardless to help people understand the types of issues that they may experience, the consequences of action and inaction, but also community resources that are available. So unfortunately, I can't sort of measure that as I sit here right now, but I absolutely agree that we need to understand the working group's analysis to be limited to what I described, and that there will certainly be additional need beyond that, including for the reasons you mentioned.
Thank you very much, Mr. Stankham. Chief, thank you very much.
Thank you. Before we move to our next speaker, and who is also our first client to address us, which is, as I mentioned earlier, the most exciting part of the program, I did want to acknowledge the presence of Administrative Judge Connolly, who joined us. I knew he couldn't be here quite on time. He was coming from a ways away, but glad to see you here. Mr. Vernell Robinson? Ms. Vernell Robinson, I'm sorry. There we are. Hi, how are you?
Hello.
Welcome, and thank you for joining us.
Most definitely.
The floor is yours.
The floor is mine?
Yep, we are delighted to hear from you.
Okay. Just a second. Okay. Well, my name is Vernell Robinson, and thank you very much for hearing me out. I'm a 6-year-old mother of 4 who raised her children in Carlton Manor, 7115 Beach Channel Drive, since 1989. I'm currently the vice president on the board of the resident council, and my daughter is also very active on the board and lives in the same building in a different apartment. I joined the board to make a difference so the New York City Housing Authority would do a better job at maintaining the 174 apartments in the building. For many years, we had problems with the hot water in our apartments because NYCHA's failure to maintain our building. In October 2021, the problem became unbearable, and we were fed up with NYCHA, blaming the residents for the problem and giving excuses for why we didn't have hot water. As a resident council, we informed NYCHA's compliance department of the lack of hot water so that they can get an inspector out to the building, but no one ever followed up with the investigation for months. This was our experience also in the past when the building was out without gas. We didn't have legal help then, and the issue lingered for months. I mean, through Thanksgiving, Christmas, Valentine's Day, before the gas was restored. As you can imagine, it was extremely difficult to live without hot water. I have a physical disability, whereas my doctor recommended that I have a shower chair. But it was difficult for me to carry the water by myself, and often I had to wait for assistance just to take a bird bath in the shower. And I wasn't alone. Many residents in the building, which are predominantly African Americans, are elderly and have had a hard time dealing with this issue as well. The residents were unable to take showers or perform their daily functions as normal. It was embarrassing to have family members come over to visit because they couldn't spend the night or stay long because they couldn't bathe in hot water. NYCHA's disregard for our dignity and well-being led some residents to pay for hotels and to take proper showers. And some of them had to seek refuge at family and friends. In fact, some families even moved out of the building because the issue was so bad. Some died before the problem even got corrected. By November and December, we had had enough and sent a letter threatening to sue NYCHA in Queens Housing Court. I thought it would be more powerful to sue NYCHA as a group, but because it was easy for NYCHA to ignore us individually. On January the 11th, 2022, however, we were told by the housing court clerk that we could not file our case as a group. I fought back because I knew our rights. But even after filing a group of 101 tenants, we were unsuccessful. Before we had a lawyer, the court didn't help us at all. So I was so relieved when Legal Services in New York City got involved a few weeks after we filed. I was so happy to have the lawyers fight for us because by this time I didn't know what to do, where to go, or anything else, but I exhausted all of my things that I thought I could do, and I assumed the case would just fall through the cracks, and NYCHA would get away with it. Some residents even became optimistic once our lawyer took the case, although some were still skeptical due to NYCHA's long-standing housing history of inaction and total disregard for our communities. Our attorney requested multiple court appearances to hold NYCHA accountable, but progress was slow. For example, HPD failed to inspect the building after our attorney made multiple requests, and NYCHA had failed to provide any helpful updates on the court dates. And in fact, it became clear that NYCHA had no idea what had caused the problem or how to fix it. NYCHA actually made matters worse by using unlicensed workers to restore the hot water, damaging everyone's bathroom, taping plastic over very large holes, and greatly reducing the water pressure for the top of the entire building. So much so that it didn't make a difference if we didn't have hot water because we couldn't take a shower because there was no pressure. Because the progress in the court was so slow, our attorney tried to pressure NYCHA to do the right thing by highlighting our case in the media. We told our story to New York Daily News, which featured our story on the front page. We were even quoted the judge who was furious with NYCHA for making low-income residents of color live without hot water during the winter. Like many, the judge could not imagine this happening in other communities, especially those who live in private houses. Nor could he stomach NYCHA's lack of remorse for what we had gone through. Being devalued and dehumanized was an extremely tough ordeal. After months of negotiations, countless court appearances, press, and filing for the contempt motion with affidavits from numerous tenants regarding the conditions in their apartments, NYCHA finally made repairs and agreed. Thanks to our amazing lawyer, we received a 25% rent abatement for all the households who joined the case. For most of us, this was an 8-month rent abatement from when we lost water pressure and hot water through the date night to restore the hot water pressure, and fix everyone's bathrooms. This was a nice surprise for tenants who are not expecting any rent abatement, and it was a perfect timing for those who had lost income during the pandemic. Some seniors had to choose between medication and food. The rent abatement gave the residents peace of mind. We're extremely happy with the results of our case. You might have no idea what it's like to be unable to take a hot shower for months at a time. But it's really hard and degrading, you know. We would not have been able to live in decency without our attorney and other legal service staff who pushed NYCHA from many different directions to treat us with dignity and respect we deserved. We are grateful for the work and thank you for supporting legal services. We hope other similar situations will be able to reach out for help from legal services in New York City. So please help them, but provide them with the funding that they need, that they may continue to help others in New York City, especially my neighbors in public housing, those who need it the most. Thank you.
Thank you, Ms. Robinson. I don't think I even need to ask you whether you think you could have gotten the same result or a good result without an attorney. Let me not even ask you that because I think that's obvious from your testimony. Let me ask you this instead, just out of curiosity, how did you find legal services in New York City? Did they find you? Did you find them?
Well, they found us. A resident had filed a case in court, and that's why I said when you're alone, you get nowhere. And I think with that class, with the group filing, legal aid picked it up from the tenant who had initially filed. So I believe she had gone to legal aid services.
Thank you. If anybody else had a question? No, thank you very much. We're going to move on to Ron Rasmussen, who is the Executive Director of Legal Service in New York City. Thank you again, Ms. Robinson, for appearing today.
Good afternoon, and thank you all, and especially Chief Judge Wilson and Chief Administrative Judge Zayas for this opportunity to appear before you. My name is Ron Rasmussen, and I'm the Executive Director of Legal Services NYC. Legal Services NYC is the largest provider of free civil legal services in the country. Our staff of nearly 700 works throughout all 5 boroughs of New York City to fight poverty and seek racial, social, and economic justice on behalf of low-income New Yorkers like Ms. Robinson. We're proud members of the New York Legal Services Coalition. You've just heard a moving story about the challenges one woman, our client Vernell Robinson, and the resident council she helps to lead faced in seeking to assert their legal rights. After years of problems getting sufficient hot water and months of litigation trying to get water pressure restored and hot water sufficient to take a shower, 101 tenants at the Carlton Manor New York City Housing Authority development in Queens were finally able to get the most basic service restored: hot water. As Ms. Robinson's daughter, Alicia, said to the Daily News, "This is the dead of winter. We need this corrected. It doesn't make any sense to me. I have to go to a hotel to take a decent shower." A years-long battle for this most essential service doesn't make any sense to me either, and should never be necessary. And it's only because of the determination, courage, and tenacity of Ms. Robinson and the other members of the Carlton Manor Resident Council that they were able to prevail. They fought hard, they got help from Robert Sanderman, a tenacious lawyer in our Queens office, and they finally succeeded after months and months of litigation, after the judge put significant pressure on NYCHA to solve this problem, and after the Daily News exposed the fact that one of the most basic needs that we all have, for hot water sufficient to take a shower, to wash your face, to do the dishes, was not being provided to hundreds of tenants for months on end. In 2022 in New York City, in publicly subsidized housing. Unforgivable. Restoring the essential services for Ms. Robinson and her neighbors was the primary goal of our litigation. but putting NYCHA on notice that they can't get away with neglecting essential services and disrespecting the humanity of tens of thousands of New Yorkers was also essential. We and our colleagues throughout the city will continue to hold NYCHA and private landlords accountable to their duties as landlords, which include the most basic provision of essential services, such as heat and hot water and water pressure to their tenants. Tenants throughout New York State remain desperate for help. In New York City, where there's a first-in-the-nation right to counsel for eviction cases, the funding is so limited that the legal services provider community is able to serve far less than half of those who are eligible for help. And that area of practice receives significantly more funding than what's received for all of the other areas of need for our clients. You may know the work of Harvard sociology professor Matt Desmond, who wrote the seminal book Evicted, a devastating account of the national homelessness problem, and who has recently published Poverty in America. Professor Desmond stated, "Without shelter, everything else falls apart." And that's certainly true. But it's also true that without safety from domestic violence, everything else falls apart. Without a sufficient stable income, everything else falls apart. Without a high-quality education and access to health care, everything else falls apart. Poverty makes things fall apart. Our staff and our colleagues throughout the state help our clients hold their lives together in all these ways that are so critical. But we can only do our work to help amazing people like Ms. Robinson and her family and friends at Carlton Manor in Queens with funding from you that supports the broad range of services that we provide. As a member of the Permanent Commission's funding working group, I join in the request for additional JCLS funding. And I underline that additional funding to achieve pay parity is essential so that we can recruit and retain the attorneys that are so desperately needed to provide the legal services you'll hear about today. Thank you, Chief Judge Wilson, Chief Administrative Judge Zayas, and the entire Office of Court Administration for your continued commitment to funding civil legal services. Without your support, the results you've just heard described by Ms. Robinson, and which were realized through the settlement of this litigation, would never have occurred. We look forward to continuing our work in partnership with all of you to address the ongoing needs of so many of our fellow New Yorkers. Thank you.
Thank you, Mr. Rasmussen. I don't really have a question, but I have an observation. It just strikes me as incredibly ironic that we have such a shortage of public funding for civil representation in these kinds of matters, that you had to spend a substantial amount of that money to fight another government organization that has a legal obligation to provide hot water and fair living conditions. It'd be bad if this was a private landlord, but this is the government spending money to get the government, a different government admittedly, to do the right thing.
It's hard to fathom. I totally agree with you. And, if you talk to NYCHA, they would probably say, well, we need funding as badly as legal services does to be able to do what we need to do.
That may be, but they didn't save any money by fighting this, right? They ended up having to restore the hot water and repairing the apartments and rent abatement.
They saved no money by fighting this, and unfortunately, there's a large measure of incompetence, I'm sorry to say, that we have to battle constantly with the New York City Housing Authority.
Yes.
Yes.
Good afternoon, Mr. Rasmussen. And again, congratulations on behalf of the work that you did on behalf of Ms. Robinson and her neighbors. It's you and and particularly the attorney in Queens who did the work deserve a round of applause. The questions that I'm going to pose to you, though, this is just for everyone else testifying today, the other executive directors. I'm going to pose them to Mr. Rasmussen, but with the permission of the Chief Judge, I'm going to ask that you perhaps respond in writing to this panel, a letter to the Chief, maybe CC the rest of us. But here are the questions, Mr. Rasmussen. I'll just ask them to you, though, right now. What percentage of the monies that you've received from the Unified Court System for civil legal services are used for direct client services as compared to operational necessities?
I would say that most of the funding that we receive from I don't have the exact percentages and happy to respond in writing, but most of the funding that we receive from the Office of Court Administration goes to direct legal services for our clients.
Very good. And then the second question is, does your entity lobby?
We are not permitted to lobby. We're funded by the Legal Services Corporation, and so there are, restrictions that prohibit us from lobbying. We can, at the written request of a legislator, opine or provide information about the impact of a proposed bill
That's different
on
from
our
lobbying.
clients.
You
But
don't
that's
have-
different from lobbying. Yeah,
Right,
that's not
different.
lobbying. Yeah.
Right, you don't lobby, okay. So then this question wouldn't be germane to you?
Although I'll just add, we are permitted to lobby for our own funding, and we do that, but we're not permitted to lobby for legislative matters.
Right, okay. And then the last question I have is, again, wouldn't pertain to you, but this will pertain to everyone else perhaps. If you are lobbying, my question is, how much, if any, of the money that's being sent from the unified courses system is being used for lobbying, or is that money segregated? Again, that wouldn't pertain to you, but that would pertain to maybe some of your colleagues. Thank you for answering my question, sir.
Thank you.
Thank you, Mr. Rasmussen, and also Ms. Robinson, thank you again very much for your time. Next, we have Mr. Lionel Harvey, who is a client of Legal Assistance of Western New York. Good afternoon.
Hi there.
I think you have something to tell us.
Yes. Just start reading.
Yes, go ahead.
Good afternoon, Your Honor. Thank you for the opportunity to be here today and for allowing me to speak about my experience. My name is Lionel Harvey. I'm 85 years old. I live in Hilton, New York, a village 19 miles northwest of Rochester, New York, Monroe County. I've joined you all today to speak about an experience I had that is sadly all too familiar to many older adults in our area. Over the course of about four years, my daughter, who was my POA, took several large sums of money from me without my knowledge. She took various personal items of value from me and used my credit card to benefit herself at my expense. Over the short period of time, she wrote over 80 checks using my checking account, leaving me almost broke. In 2015, my daughter suggested that I deeded my house to her. She would help me to care for my wife, Joanne, who was very ill at the time. My wife passed away in July 2019. I did as my daughter had asked and deeded my home to her as we're making her my power of attorney in October 2015. My daughter then took control of everything, my spending, savings, all of my credit cards, accounts. Without my knowledge, she depleted almost everything I had. When I finally noticed this, she tried to tell me that I told her that she could have all my money. She then turned hostile, erecting a door to prevent me from using the laundry room and the kitchen, from having access to the side of the house. I was even left without no food, my part of the house. My daughter asserted so much control over my life that I was not allowed to do dishes in the kitchen sink and to use the bathroom sink. She told my grandchildren that they were not to speak to me or to help me, and put up a sign warning me that I was being surveilled by her. I love my daughter, and even while this was happening, I wished her a happy birthday. She didn't respond, and I was devastated. That summer, she put garbage in my car on my 80th birthday. I was given a 2012 Cadillac by my daughter, sold this car. My daughter sold this car. I didn't receive anything for it. When I confronted her about the spending, she no longer allowed me to have breakfast, lunch, or dinner with my family. I was referred to Law New York in May 2021. Jeffrey Nazansky and Karen Kemholtz from Law New York helped me regain control of my life. With Jeff's help and the help of the accountant, lifespan provided, we discovered that my daughter had stolen over $227,000 from me in addition to several items of personal property. Together with Law New York, I filed a lawsuit in the Supreme Court with the assistance of my mediator. We negotiated a settlement that resulted in a lump sum of $80,000, monthly payments of $1,200 for up to 60 months, and the return of my valuable personal property. More important to me than the money was that I was alive to live with dignity again. Now, my son is my POA, and I don't know what I would have done without him. He helped me so much. I live away from my daughter in my own apartment that has everything I need, including air conditioning and friends nearby. I'm still getting over what my daughter did to me, but with time and with the help from people like Jeff and Karen at Law New York, I know I will be okay. He helped me during some of the hardest times in my life, and I will always be grateful. Lionel Harvey.
Thank you, Mr. Harvey. I am deeply sorry for what you had to go through. I think it's probably hard for anybody to imagine how painful something like that must be. I'm glad you finally were able to get help. I don't know if anyone on the panel has a question. But if not, I think we would like to hear from Ms. Lori O'Brien, who is the Executive Director at Legal Assistance of Western New York.
Thank you. And on behalf of Law New York, I want to extend my gratitude to you, Chief Judge Wilson, the distinguished panelists. I really commend Mr. Harvey for his willingness to share his story today, and we appreciate the opportunity to be part of that story. As you said, my name is Lori O'Brien. I'm the Executive Director of Legal Assistance of Western New York, Law New York. I've been a civil legal services practitioner for over 16 years. And today I'm going to share some brief comments about Law New York, our services to older adults, and in particular in the areas of elder abuse and financial exploitation. Law New York's vision is a society where access to justice is not determined by a person's social or economic status. Law New York provides civil legal services to residents of 14 counties located in 3 judicial districts, the 6th, 7th, and 8th, and 2 departments, the 3rd and 4th. Our geographic reach includes urban, suburban Monroe County and 13 rural counties, spanning just a little less than 10,000 square miles. The primary services we provide to older adults includes assistance in securing and maintaining safe housing, obtaining and maintaining health and medical resources, including long-term care, and other income supports to meet their basic needs. It also includes transactional work, preparing legal documents which support self-sufficiency. And finally, it includes preventing and remedying the ill effects of elder abuse, financial exploitation, and scams. Approximately 1 in 10 older adults experience some form of elder abuse. In New York, it's slightly higher. Elder abuse and financial exploitation cost individuals, taxpayers, the government, millions upon millions of dollars annually. Many individuals like Mr. Harvey would have never needed our services but for the loss of income and resources resulting from financial exploitation. Now, despite its prevalence and its financial impact, only 1 in 44 cases of financial abuse is ever reported. Why is that? Individuals often act under the perceived authority of something like a power of attorney. Many individuals, especially those living in poverty, are dependent upon family members. There can be feelings of secrecy or shame. There's complicated family dynamics. There's love. And it is not a subject that is easily shared. Now, sometimes community members don't understand or recognize elder abuse, neglect, or exploitation when it's happening. When they do recognize the problem, they often do not know where to turn for help. Our work has shown that civil legal services in this area, particularly in combination with effective non-legal services, can make a tremendous impact. Legal services can play a proactive role in elder abuse prevention, conducting community outreach, educational workshops, awareness campaigns, One-on-one counseling can increase knowledge about abuse, its signs, and available resources for support. Having access to legal advice and information, older adults can make informed decisions to protect themselves and to seek help when necessary. And these cases often involve complex legal matters relating to guardianship, healthcare decisions, and estate planning. Legal services can offer specialized knowledge in these areas, ensuring that interests are protected and respected. Legal services can assist victims in recovering assets, preventing further financial exploitation, holding those that commit acts of exploitation accountable. And this is particularly important because financial exploitation can leave older adults in dire financial straits, affecting their overall quality of life. Now, legal services, we believe, are most effective in combating elder abuse and financial exploitation when that work is done in collaboration with others, support organizations, social services, healthcare providers, at times law enforcement agencies. By coordinating efforts, they create a comprehensive network of assistance for elder abuse victims, ensuring that all aspects of the issue are addressed effectively. Law New York, throughout our 14 counties, is fortunate to have well-established partnerships. Mr. Harvey connected to our services through the work of Lifespan. Lifespan staff collaborated with Law New York throughout the course of the case, bringing essential resources, expertise, and support, not just to Mr. Harvey, but to Law New York and our staff that worked alongside him. Lifespan also administers enhanced multidisciplinary teams. These are county-based teams that bring together various disciplines, including civil legal services, to intervene in these types of cases. Now, Law New York is fortunate to have specialized expertise in areas, as Mr. Harvey mentioned, his attorneys, Jeff and Karen. We're very thankful for the work that they do and the impact they have on the communities they serve. We also have challenges. Many of those challenges have been expressed here today. In Law New York's experiences, two primary issues are impacting access to legal services for older adults in our geographic service area. The first is the well-documented lack of attorney resources in rural communities throughout the state of New York. Those that practice in these areas of the state often have to turn clients away due to lack of resources, conflicts, lack of subject matter expertise, or the potential client's inability to afford representation. Civil legal services works to fill the gap created, particularly when counsel is unaffordable. However, with a limited number of attorneys, we also fall short of meeting the need. Compounding this is the current competitive hiring market and non-competitive salaries for civil legal service practitioners. And I'll refer you to the written comments of the New York Legal Services Coalition, which Law New York is happy to be part of. The second issue is inadequate resources to handle complex legal cases. Bringing civil litigation against individuals committing acts of elder abuse and financial exploitation is complex, and it's time-consuming. Mr. Harvey's matter alone required 207 service hours. Older adults are often unable to find affordable counsel or free civil legal services to undertake complex or litigated matters. Elder abuse often involves prolonged periods of financial exploitation, requiring specialized forensic and litigation skills. Victims may have cognitive impairments, loss of capacity, communication challenges, and significant dependence on their caregivers, which complicates fact investigation and the development of legal remedies. Increased funding in this area would reduce the number of individuals seeking assistance who are turned away and allow us to increase outreach efforts in hard-to-serve areas, particularly our rural areas, where community members may be isolated from resources. It would also increase our ability to provide full representation in complex matters. I want to thank you all for allowing Mr. Harvey and I the opportunity to illustrate the challenges faced by older adults, the significant impact that civil legal services have on remedying the ramifications of elder abuse and financial exploitation, and the need for continued and expanded support to these programs and services. And before I close, I want to thank you. The support we already receive from the judiciary makes a profound impact and allows us to take on these types of matters that can create meaningful change in the lives of our community members.
Thank you, Ms. O'Brien. I had a couple questions for you. One goes back to a question that Presiding Justice Whalen asked earlier, which is, I'm sure that, for example, in housing, eviction cases, there are some people who are threatened with eviction and they just leave and the case never gets to court, and so we don't know what that volume is. But from your testimony, it sounds like that may be a much greater fraction of cases in elder abuse, where there are people you aren't reaching because you don't know that they have problems. Well, how can additional funding help address that?
I think, and especially when we put this in alignment with the rural attorney shortage, it really has to be a multi-pronged approach. But one of the most impactful is outreach. And when we know in our rural communities in particular, many people are isolated from resources, we have to become more creative about how we're reaching out to people, how we're collaborating with other organizations, both nonprofit organizations or social services, but also places where people go and see people they trust. I'm talking about outreach to medical centers, outreach to religious communities. If you're having an issue with your life, who do you go and seek counsel from? Those partnerships with legal services can actually help us reach individuals who may not have come to our door or been able to contact us. Often when you look, and if you look at Law New York service area, a number of years ago, we looked at data where our clients are coming from. And so often the bulk of clients are coming from this 30-minute radius around our local offices. So the number one way we need to reach out, beyond having additional staff to be able to do that, is outreach and being creative in that outreach and in finding ways that we can connect with community members.
The other thing I was curious about is that it in some cases, the behavior, the exploitative behavior could cross the line into criminal. And so I was wondering how and if you interface at all with local district attorneys or the Attorney General's office, and whether it assists. I can also imagine reasons why somebody might not want a loved one prosecuted. So the complicated dynamic there.
Absolutely. And when we think about our staff that are involved in these cases, understanding that complex family relationship, it's really important to helping individuals find the solution that they're choosing, right? We do interface, though, with law enforcement and district attorneys' offices, whether that is helping an individual pursue a type of complaint, or it's within these multidisciplinary teams within our communities. And I think that collaborative approach really is what allows us to achieve the best result for that client, which may be litigation and maybe a litigated result in some cases, but often it's a negotiation that attempts to preserve the family relationship.
Thank you. I don't know if anybody on the panel had a question. No. Then thank you very much, Mr. Harvey and Ms. O'Brien.
Thank you.
Next, we're going to hear from Bobby Defoe, who is a client of Volunteer Lawyers Project of Central New York. Oh, I'm sorry, I skipped Terry Tupper.
Hi, I'm sorry, I didn't get audio till just now. This is Terry Tupper. Is it okay to speak?
Hi, Terry Tupper. Yes, this is Rowan Wilson, and we've got your panel here, and yes, it is your turn. I inadvertently almost skipped over you, but I'm glad you're here.
Thank you so much. Good afternoon, honorable judges. My name is Terry Tupper. I have been a client of Empire Justice Center on and off since 2008, and I was a member in 3 class action lawsuits. The outcome of these lawsuits improved my family's quality of life. In 2007, I was diagnosed with severe lipolymphedema, which is the combination of 2 highly inflammatory disorders. The 2 conditions in tandem cause severe swelling in my lower extremities that without daily compression and decongestive therapy leaves a hardening of the tissues which is irreversible. Because I could not afford compression garments at $2,000 a pair, infections followed one after the other. I endured many hospitalizations, sometimes for weeks, with extremely high fevers that led to sepsis. Coupled with other autoimmune disorders, this all forced me to stop working. I had been a nurse LPN since 1990 and also in the medical billing field since 1999. I quickly became bedbound and had to rely on Social Security disability income. Around 2008, my family was having difficulty getting through the Medicaid application process. I reached out to Linda Husberg, Esquire at Empire Justice Center, and became a client in a class action suit where ultimately I was granted access to Medicaid. While she was assisting me, I explained to Ms. Husberg that I could not get the custom compression garments I needed. Ms. Husberg referred me to another class action in progress that was to ensure compression stockings were included as a Medicaid benefit. That suit was also successful, and I eventually was able to get compression garments, begin physical therapy, leave the bed, and over the next few years get considerably healthier. I became an advocate for people with disabilities, as well as a New York State ambassador for the Lymphedema Treatment Act, petitioning on a federal level for similar rights to those with which Empire Justice won at the state level. The Lymphedema Treatment Act was passed by Congress, and the new insurance coverage will go into effect on January 1st, 2024. In October 2018, my family was rendered homeless due to a holdover eviction, wherein the Suffolk County Human Rights Commission later found probable cause existed that the landlord had engaged in discriminatory behavior. My family was approved for temporary housing assistance, but Suffolk County Department of Social Services denied my reasonable accommodation request for my own hospital bed and a dorm-sized freezer to store the ice packs I needed to alleviate the swelling. So I reached out to Linda Husberg again and became a class member of an action Newkirk v. Pierre, filed on behalf of Suffolk County residents with disabilities who needed reasonable accommodations to access Suffolk DSS benefits and services. After being informed by DSS representatives if I asked for my hospital bed to come with me to shelter again, I would instead be sent to the nursing home. Ms. Husberg made a phone call, and my reasonable accommodation requests were immediately granted. In 2020, my family came up on a HUD mainstream list and qualified for Section 8. We gratefully turned in our voucher to accept project-based housing in Bayshore, where we now still reside. Since we have been in permanent housing, our 16-year-old son, who was originally a straight-A student before we became homeless, has gone from failing almost every subject to cum laude status and is on track to become a biochemist. My son has expressed that one day he would like to find the cure for lymphedema. Drawing on my lived experience, I co-founded a grassroots not-for-profit called Long Island Connections in an effort to assist others by connecting them with resources and advocacies such as Empire Justice Center. We host a peer support group on Facebook called Homeless LI, which has a member base of over 3,000. We also have a mobile medical equipment lending closet and work with the local VA and the community. In this work, I came across the organization Legal Hand offering remote volunteer positions where I could do work similar to what I was already providing in my own group, but on a larger scale. I jumped at the chance. Well, if I could, I would have. Soon after, Long Island Coalition for the Homeless saw the work that I was doing and offered me a part-time paid position assisting on their helpline remotely. I have now been with the coalition for 15 months and volunteering at Legal Hand for nearly 3 years. I am striving to work full-time again and no longer be dependent on Social Security disability income. My firsthand experience as a person with long-term disabilities and lived experience homeless has greatly informed my work in advocacy every day, and I would not be where I am today if it were not for the assistance of Empire Justice Center. My contacts with Empire Justice Center and Linda Husberg did not end with the 3 class action suits. There were many ADA questions and questions related to DSS policy and procedure, which led to dozens of exchanges along the way. Their advocacy has been incredible, and I am so grateful. Without Empire Justice Center's assistance, I would never have known the power of a reasonable accommodation under the ADA. My life is propelled forward now in a positive and uplifted way. I have tools I so desperately needed to piece life back together for my family, and I am a survivor now instead of a statistic. Thank you.
Ms. Tupper, I'm just overwhelmed by not just the things you've been through, but your bravery and your persistence and determination, not simply to get through your various medical issues, but to, then persist in doing what you can for others too. It's really moving, and I thank you for sharing that with us. I hope your son, congratulations to him. I hope your son does find a cure. But if he, for whatever reason, decides not to become a biochemist and decides that a lawyer is a second best career, I think anybody sitting up here would be glad to talk to him at any point in time to help him along the way. It's the least any of us owes you. So
Thank you, Judge. I might take you up on that one day.
you should, I mean that in all honesty, and I think that everybody
Thank you.
sitting up here would be more than happy to talk to you, talk to your son and you.
Thank you.
It's really quite amazing what you've done. I don't have a question, but perhaps someone else does.
I just don't know how your lawyer is going to be able to speak after this.
Thank you.
So next we have Kristen Brown, who is the President and Chief Executive Officer of the Empire Justice Center.
Thank you so much, and thank you, Terry, for being here and sharing your story. It's incredibly powerful. Good afternoon. As noted, my name's Kristen Brown, and I'm President and CEO of Empire Justice Center. We're a statewide, not-for-profit law firm, an advocacy organization. We have 7 offices around the state in Albany, Rochester, Yonkers, White Plains, Central Islip, where we have worked with Ms. Tupper, and Hempstead. We focus on areas of law where we can have the most impact, and we have a goal of addressing the root causes of injustice through our 360-degree approach to systems change work. We center the client experience to identify barriers, and then we break those barriers down using targeted training, legal intervention, and policy advocacy. In this way, we practice, we teach, and we change the law to make it work for all New Yorkers. Thank you so much, Chief Judge Wilson, and our esteemed panel members for allowing us to be here and talk to you today. Empire Justice Center is deeply grateful for the Office of Court Administration's ongoing commitment to civil legal services. The JCLS funding is absolutely essential revenue for Empire Justice Center and our peers. It's a key element in our ability to help our clients, like Ms. Tupper, access justice under the law. We're especially grateful for the commitment to cost of living adjustments for the JCLS funding, which has really helped us to absorb the increased cost of doing business. As I'm sure you're aware, every year, rent, health insurance, office supplies, the less interesting but integral elements of doing this work rise. And until 2022, our JCLS funding did not reflect this. So just thank you so much. It's also that funding, the JCLS funding, is absolutely critical to our ability to hire attorneys to represent clients in the essentials of life in both individual and impact cases. As you heard from Ms. Tupper's involvement in not 1, but 3 separate cases, our impact cases address the need for timely economic and medical resources that, once they're available, serve to dramatically change her life for the better. And Ms. Tupper was just one of over 365,000 New Yorkers who benefited from these 3 cases combined. When we're successful in these types of cases, our experienced attorneys ensure that scores of New Yorkers are able to assert their civil rights, access government benefits, and critical services that stabilize folks' lives so that they can focus on their jobs, their school, their family, focus on putting food on the table in a safe and stable home. These are the essential aspects of everyday life. And the ability to do this work is particularly important for marginalized communities, including Black and Brown New Yorkers, LGBTQ+, and low-income individuals and families, folks with disabilities, and so many others. Examples of current cases in Empire Justice Center's civil rights practice right now include a pandemic-related action involving thousands of bus drivers and bus attendants who were denied unemployment benefits, and a case addressing lack of access to special education services for thousands of students with disabilities across the Rochester City School District. Life-altering systems change cases like these require a high level of expertise and talent. Seasoned attorneys are needed to guide our junior attorneys in their professional development and to supervise their work. Unfortunately, as you've heard throughout the afternoon, filling positions has become increasingly difficult. Our civil rights managing attorney position has remained vacant for the better part of a year, and we have vacant housing, immigration, language justice, and education debt advocacy positions. At the same time, the need for services is so great we could easily triple the work that we're doing if only we could fill these positions. Speaking from colleagues across the state, and you've heard today, hiring challenges and the acute need for services are not unique to Empire Justice Center, and they're not just in rural regions. A key element of the challenge in filling these critical roles is that civil legal services salaries are so much lower than our peers in public interest law, including those working at public defenders' offices within county and state government, and certainly within the private bar. And while we were incredibly supportive of the much-needed increase in assigned counsel rates last year, increasing salaries in other areas of public interest law widens the public interest salary gap in the civil legal services recruitment challenge. Recognizing this, over the summer, the New York Legal Services Coalition, which we are a proud member, and is also the membership association for civil legal services organizations across the state, conducted an informal survey of salary data from legal services providers. And preliminary findings indicate that civil legal services attorneys earn approximately 20 to 40% less than their counterparts that work directly for the government. This is hard evidence demonstrating what we've known anecdotally for a long time. Starting salaries in civil legal services are consistently the lowest paying public interest attorney jobs across the state. The widening salary gap is making it increasingly difficult to attract and retain legal talent, despite the passion that people have for working in our community. And of course, unfilled positions result in clients not served, unlawful evictions executed, homes lost to foreclosure, life-saving health coverage not received, similar to what we were able to do in Ms. Tupper's case. We all share the same goal of ensuring that justice is served for those who need it most. And in order to achieve this goal, we have two requests for you all. First, we ask that you continue to make progress towards closing the justice gap by increasing JCLS funding by a substantial amount so that we can meet the overwhelming need. Second, we ask that we are able to come together to solve these salary and recruitment and retention challenges as well. To do this, we ask that you work to develop a plan to engage in discussions with the governor and legislative leaders so that we all can work together on a multi-phase plan to achieve pay equity across government-funded public interest legal systems. We recognize that these are not small problems to be solved, but our community working with our partners in government solves intractable problems all the time. We know how to do this. So together, we can continue to close the justice gap. We can expand services into critical areas of law, such as medical and consumer debt, public benefits, while also taking steps to ensure that our civil legal services providers are able to recruit attorneys with the skills and ability to meet those challenges with us. Thank you for your attention today, for your past and future support of Empire Justice Center and of our colleagues in the civil legal services community.
Thank you very much. As to your last point, I guess I have a comment and a question. The comment is that Chief Administrative Judge Zayas and I and the other Deputy Chief Administrative Judges have in mind the importance of what's been called pay parity, that you need to be able to pay commensurate with what the government pays people doing the equivalent work, because otherwise there won't be anybody on your side. And the consequences to that, as we've been hearing today, are, if you imagine that none of these people would have had adequate representation, or maybe representation at all, would be quite drastic. The other is, roughly, I'm sure I can find this information out elsewhere, but roughly what fraction of your budget is personnel costs? I assume it's about 80% or so.
It actually is a little bit higher than that, and Judge LaSalle's question earlier, when it comes to our JCLS funding, about 10% goes towards our overhead costs, and the remainder is for salaries and personnel.
And so that sort of implies that if we're looking at a 20 to 40% salary shortage and we can knock off 10 or 15% of that from overhead, we're still talking about a pretty substantial increase in what you need to bring you up to parity.
I would say so. I mean, it's that, and that's why I say it's not a small problem to solve. At the same time, if we even are able to start taking steps and a phased-in approach, I think that would go a long way. And what you find if you look across the state, as we all know, the cost of living is different in different parts of the state, and so the magnitude of the problem also varies across the state.
Thank you.
So if I make, the majority of the monies you're receiving from the unified court system are going to your core mission, not to ancillary matters, right?
Absolutely, 100%.
Thank you very much.
Thank you.
And thank you, Ms. Tupper. So next.
Thank you.
Next, we have Bobby Defoe, a client of the Volunteer Lawyers Project of Central New York. Hello there and welcome.
Hello.
We are ready to hear from you whenever you are.
Okay. My name is Bobby Defoe. I am here to talk about my experience with dealing with medical debt and the difference that having help from the Volunteer Lawyers Project of Central New York made in my life. It was a year I was battling breast cancer. I'd had pain, went to a hospital and got really unsatisfactory service. I was insured at the time, but my deductible was $5,500. After that, I remember only getting one call from the hospital about the bill. Was never offered charity care. I started a new job after the pandemic. I had gotten COVID and used the hospital services. Again, shortly after that, I get a letter saying that my wages were going to be garnished by the hospital from the sheriff. I immediately panicked. There wasn't much of a time frame to work with. The papers gave me very little time to fight it. The garnishment was for way more money than the original amount I owed to the hospital because of interest. I felt very overwhelmed. I almost didn't do anything, but I knew it would devastate me if I had my check garnished. And I felt like the garnishment was sketchy. I had never received any paperwork at all about being sued or having a judgment against me. I finally called legal aid in Cortland, which took a while, and I spoke to a few different people. And I was told they couldn't help me because they were too busy. One of them connected me to Volunteer Lawyers Project of CNY and told me that they might be able to help me. I started working with Adam, who was not an attorney at the Volunteers Lawyers Project. He asked me to share all of the paperwork that I had and asked me questions about everything that had happened. It immediately started to make me feel better. Then Sal started getting involved as an attorney and explained to me that the service was garbage. They said that they had served me years ago and they had not. They served me at a different address, the summer cottage of a relative. Sal helped me prove that it was never my address. They also helped me prove that I was eligible for charity care and should have been offered financial help by the hospital. They helped me file paperwork to vacate the judgment and worked with the hospital's attorney to take care of everything. When I got the news that the judgment was vacated, I never felt so grateful in my life. I never saw that coming. What better news could there have been? I absolutely would not have been able to fight this garnishment on my own. The legal service saved me headache and financial ruin. But I also thought about all those people who just go along with it and have no idea that there are legal services out there. They don't even know that they have a right to financial help with medical bills, and they don't know how to fight bogus lawsuits like this. I wish that when people get this paperwork that there is a number to call for help and that there are more lawyers available I want to thank you for this opportunity to tell my story and for your support of free legal services.
Thank you very much for taking the time to share it with us. It isn't, you mentioned that people might not know that there would be legal service available, but, there was a point when you were telling us what happened that really resonated, which was that even if you knew, everything that somebody's going through might just be debilitating. You might sort of know, well, I could maybe fight this, but just feel so overwhelmed by health issues, by the bill, by the threat of garnishment, by anything else that's going on in your life that you might, it really takes some, I can imagine people thinking, I'm just giving up, which would clearly be the wrong thing to do, and it's lucky you didn't, I think, or maybe not so much lucky, but testament to your strength.
Yes, absolutely. Like I said, I mean, you freeze, like, what am I going to do?
Right.
You don't know what to do until you connect with somebody.
And
they saved me a bunch.
And when you called legal aid and they said, we're too busy, I can also imagine that might have been discouraging, but for the fact that they were able to connect you with somebody.
Yes, I didn't give up. I tried calling and it was really nice. I mean, they said, try this, which connected me with SAIL, the Volunteers Lawyer Project, which, I just couldn't have asked for more understanding and helpful people to work on this with me. Just put a little legwork in and it just came together. It was awesome.
Don't know if anyone had a question for you. Otherwise, stay on the line and we're going to hear from your attorney, Mr. Curran.
Okay.
Hi there. Good afternoon, Chief Judge Wilson and the esteemed panel of judiciary and bar leaders. I'm honored to have the opportunity to speak with you, and I want to start by expressing my gratitude for your continued attention to and leadership with addressing gaps in justice in New York. My name is Sal Curran, and I am the Executive Director of the Volunteer Lawyers Project of Central New York, and I was Bobby's attorney as well. We are a pro bono legal aid program in Central New York whose mission is to provide access to justice by engaging the legal community in service to those in need. In the past year, our staff of expert attorneys, pro bono coordinators, and legal assistants worked together with our volunteer panel of over 600 lawyers, law students, and paralegals to serve over 4,000 clients in Central New York and throughout upstate, benefiting over 10,000 community members. Volunteer Lawyers Project of CNY focuses on addressing civil legal needs that other legal aid organizations either do not address or cannot fully meet. I want to thank our client, Bobby, for sharing her very personal story. Bobby has demonstrated tenacity and strength in fighting an unjust legal action, even when doing so felt nearly impossible. Sadly, Bobby's experience of facing a crippling medical debt is not unusual. Time and again, we see that individuals with low incomes are disproportionately affected by medical debt due to being uninsured or underinsured, and that there are few or no legal aid attorneys available to help them navigate the very confusing process of fighting debt. When we did a civil legal needs survey in 2017, debt was one of the most common legal issues. We then met with the other legal aid organizations to find out what services were available, and were horrified to find out that there was only one civil legal aid attorney in the surrounding 13 counties whose practice was devoted solely to debt and bankruptcy matters. 1 in 13 counties. We began serving debt clients in 2019 and repeatedly met individuals who faced medical debt. Now, medical debt is especially onerous because it's often sudden, unplanned, unavoidable, and extremely expensive. The people we were seeing should have qualified for financial assistance from the hospitals pursuant to New York public health law, but either had never been offered assistance or couldn't navigate the system on their own. With medical debt, as with all debt cases, we saw clients like Bobby where sewer service meant that they were never made aware of the lawsuit, leading to a default judgment. We know from reviews of court records that there are thousands of more individuals throughout New York that are defaulting on their medical debt cases in court, whether due to issues with service or simply feeling too overwhelmed to respond. Now, last year, Elizabeth Benjamin from the Community Service Society of New York presented very impactful testimony on the prevalence and impact of medical debt in the lives of low-income New Yorkers. Since that time, Urban Institute published a study on the disparities in medical debt in New York by region, race, income, and other factors, which are covered in greater detail in the written testimony of the New York Health Foundation, who I want to thank for funding our medical debt work over the past year. One finding that was both upsetting but also unsurprising to me was that Central New York is disproportionately affected by medical debt. While an estimated 6% of consumers in New York have medical debt in collections, in Central New York, we have the state's highest rate at 14%. And even within this region, there are disparities, with 28% of our low-income communities of color being burdened by medical debt. And I will say these communities, incidentally, also have the greatest number of eviction filings in court every year. With our new focus on medical debt, we have discovered how ruthless some of the hospitals can be. We recently had a hospital continue to pursue a debt lawsuit against our client who had stage 4 pancreatic cancer for over $10,000 medical services related to cancer treatment he received during a time when he was dropped from his former employer's insurance while on disability before Medicaid had gone into effect. Despite knowing his diagnosis was terminal and that he was near death, the hospital continued to pursue the lawsuit right up until he died, refusing to waive or reduce the amount owed. We know that the stress of being unable to pay back debt and dealing with debt collectors can result in negative health consequences. Those struggling with medical debt have been found to be 3 times more likely to experience anxiety, depression, elevated stress, and even an increased likelihood of suicide attempt compared to people without medical debt. Sadly, we've also seen this to be true. A single mother of a disabled child had been in a car accident that resulted in over $8,000 of medical care for the 2 of them. While they had Medicaid, no fault should have covered the costs, but the overwhelmed mother wasn't able to complete the no fault application in the narrow 30-day window required. The hospital obtained default judgments against her, which she only discovered when she was trying to start the process of saving up to buy her first home. Neither Medicaid nor the hospital would provide her any financial relief, and even though at the time she was, by all standards, indigent. Unfortunately, she came to us during the worst shutdowns of COVID, and we were unable to resolve the matter at the time due to the courts being closed. When we followed up later, she never responded. 2 years after coming to us, she took her own life, a tragedy that was felt throughout the community. Volunteer Lawyers Project of Central New York has many suggestions on how to address medical debt. Because there continue to be real concerns regarding sewer service and nearly all cases proceed on default, medical debt lawsuits should require additional notice directly from the courts to the respondent about the action so that the courts are aware when the mail comes back as undeliverable. Cases should not be allowed to go forward on default without the court doing its own inquiry into whether all laws regarding medical debt, including that patients must be screened for financial aid eligibility pursuant to public health law, have been complied with. The court should develop a simple standard answer form for individuals to use if they cannot obtain a lawyer so that they will be more able to make an appearance. VLPCNY calls on the court to establish a medical debt part to bring resources and special attention to addressing medical debt. And of course, I propose that this pilot court should be in Central New York, given the disproportionate share of debt burden in our region. As Bobby said, courts should provide information to all respondents in medical debt cases, letting them know about free legal assistance and legal information that's available. But more importantly, or most importantly, given how devastating and pervasive medical debt is, it is critical that the New York courts take action to ensure those who face medical debt have their rights protected through expanding access to attorneys. To that end, we ask that you continue to make progress towards closing the justice gap by significantly increasing judiciary civil legal services funding as you are able to do so. Funding is needed, as we have talked about today, not only to create and expand programs, but also to ensure that civil legal aid programs are sustainable and able to attract and retain the experienced attorneys needed to litigate difficult cases and supervise pro bono attorneys. As a board member of the New York Civil Legal Services Coalition, I was one of the ones who helped conduct an informal survey of the legal aid organizations that found consistently that civil legal aid attorneys are paid 20 20 to 40% less than their public service peers who work for government, which of course leads not only to difficulty in hiring, significant rates of attrition, but practically speaking leads to overwhelming caseloads, high levels of burnout, and means less clients served. The consequences of medical debt are dire, and low-income New Yorkers must have access to attorneys when they are in need. Thank you so much for the opportunity to speak to you on this important matter, and I direct you to my written testimony for statements regarding the urgent need for legal representation in eviction proceedings as well, since upstate the caseloads are simply untenable and so many tenants go without representation. I thank you for your support of the Volunteer Lawyers Project, CNY, and your support of our colleagues throughout the civil legal services community throughout the state. Thank you.
Thank you, Ms. Curran. So what fraction of your workload roughly is handled by volunteer lawyers, and how do you find them and interest them and keep them?
So prior to COVID, I would say approximately 70% of our cases were handled by pro bono attorneys. During COVID, the rate of volunteership dropped pretty dramatically. We're now working our way back up to that rate. We recruit in every way possible. So for any private attorneys that happen to be watching this hearing, you know how to find me. But no, I will say, without joking, you know, we partner very closely with the Onondaga County Bar Association, which is our, they were our founding agency 30 some odd years ago. They help us a lot. We provide free legal trainings to attract attorneys. We provide really quality supervision, which makes it so that attorneys who want to go outside their regular practice area are able to do so. And we provide a wide variety of volunteer experiences, everything from 2 hours of volunteering at the local library to answer legal questions, to providing ongoing representation in very complex cases like immigration asylum cases.
Yep, Mr. Lewis.
Just really quickly, one of the issues that seems to permeate the testimony that you and your client gave and those who preceded you is how many people may be falling through the cracks. And I'm wondering, how do we get the information out there that there's an answer, that there's if you had enough manpower there'd be an answer, but how do you get the word out so that people become educated that there's help out there potentially?
Yeah, thank you for that question. You know, we get the word out there by about as many ways as you can imagine, but I will say that the courts are one of the best messengers of where free legal aid is available. We partner very closely with the 5th Judicial District, and for our family court program, they post our flyer. For our surrogate court program, they hand out little cards with our info. With our eviction program, it's right there. Our debt program, they post it on their wall. So the courts are a unifying place in the sense that anybody who has been sued will end up there if they don't default. Now, the bigger issue is the defaults, right? Medical debt, it's like 98% defaults. Eviction proceedings, even the city of Syracuse, where we have some representation, but by no means universal representation, default rate is over 50%. And that's the really challenging part. Where we've had the greatest success is through community outreach with trusted partners. So it depends on the program that we're talking about or the area of law that we're talking about. It could be anything from working with refugee resettlement groups to the to our debt counseling program that our city provides for free. And then I'd say the last major partner, and then the Bar Association, of course, sends along a lot of people, the libraries do, and our partner legal aid organizations throughout the region. You know, we keep track of what each other do so that we can try to get people to the right place without a runaround. And, you know, Law Help New York is helpful for that, for the unrepresented litigant as well. There's always more to be done, though. I know there were questions about the amount spent on direct legal services versus not. And, we all run these insanely lean practices. If you compare to legal aid or to a private practice law firm, you'd be like, how do they do what they're doing with so little administrative support? And as a result, it can be very difficult to do the level of outreach that we'd like to do into the community, and we really have to depend on our community partners to do it.
Thank you.
Chief, if I could briefly?
Absolutely.
Yeah, I think this is an appropriate time to point out Council Curran's great comments regarding how important it is for the bar associations to work in conjunction with the courts and with the legal aid community, legal services community. Judge Murphy, who's I believe still in the courtroom, was president of the Onondaga Bar Association before becoming administrative judge, and he no doubt brought to that administrative judge position a real understanding of the importance of the bar associations and the importance of the work they do with the various legal aid services corporations and societies. So just a pat on the back to Judge Murphy for all the great work he's done, and now as deputy administrative judge, he's going to be even more influential in that regard. I'm certain of it.
Thank you. Thank you, Ms. Curran and Ms. Defoe, for joining us today and for your remarks.
Thank you.
Next is Robert Burek, who's a client of Neighborhood Legal Services, Inc.
Give Murphy a raise there, Chief.
Could give us all a raise. Mr. Burek, thank you for joining us.
Hello, good afternoon.
Good afternoon. We are ready for you.
My name is Robert Burek. I'm 62 years old and I'm disabled. I have a limited income because I'm consisting of Social Security disability and a small pension. And my wife and I moved into our house it was a mobile home in a manufactured home park in 2017. My daughter passed away in early 2019, and after struggling with our finances, we fell behind on our rent in 2020. To help afford the rent, we applied for and began receiving Section 8 housing assistance. However, our past due balance remained. My mother passed away in May of 2020, followed by my wife's passing in February of 2021. Fortunately, the manufactured home park did not push for eviction for my unpaid rent. However, in mid-2022, the owners sold the park. I reported the sale of the manufactured home park to my Section 8 provider. The new park owners did not demand payment of my rent arrears until November of 2022, when they sent me a 30-day notice to pay or quit. When I looked at the notice, the amount demanded was much higher than what I owed, what I knew I owed. I contacted Park for an updated ledger. After reviewing the ledger, I discovered that no Section 8 payments had been received by the park for 5 months. That increased the amount owed to the park by almost $1,000. I tried to contact my Section 8 provider, and I was unable to reach anyone. I was expecting a very small inheritance from my mother's estate, but I knew that I would not be able to afford to pay the extra $1,000. In addition to what I previously owed, I feared that I would be evicted if I didn't find some help. When I contacted, I then contacted Neighborhood Legal Services, and I was linked to one of the attorneys. My attorney obtained payment records from my Section 8 provider and discovered that the park owner had not received payments because they had not submitted the paperwork necessary to transfer my Section 8 benefits. However, my Section 8 provider had continued making payments to the prior owner. My attorney provided the forms necessary for the park owner to complete, forwarded them to the new park owner, and explained the situation, helping them to understand that they would need to seek the missing Section 8 payments from the prior owner. My attorney also negotiated for me to pay the remaining balance due. As a result of the assistance I have received from Neighborhood Legal Services, the new park owner waived my late fees and never started eviction proceedings against me. Without legal services assistance, not only would I have been at risk of homelessness, but the park would have obtained a judgment against me for the court costs, attorney fees, and amounts already paid by the Section 8 program on my behalf. The eviction process could be very stressful and complicated for tenants without legal assistance. I hope that my testimony helps shed light on how important civil legal services are for housing stability for tenants like me. Thank you for your time.
No, thank you for yours. And it also, your testimony illustrates how, you have a series of really misfortunes with the passing of your mother and your daughter, and compounded on that then is this mix-up, not of your fault at all, where the Section 8 money is going to the wrong place, and, hard to know how to straighten that out without some help. How did you know about legal services?
I had looked online for legal help, and I found out I couldn't afford a lawyer, and I found out that I could possibly apply for free legal services, which I did.
Was it difficult?
A little bit daunting.
Was there anything that would have made it easier?
Somewhere along the line of being able to ask someone, who I could go to.
Was there a court proceeding started before you were represented, or no?
No, they never started proceedings.
Okay. I don't know if anybody else on the panel has a question for you. No, it looks like not. So we should hear, I think, from Mary Hanson, who's the program director for the eviction prevention program in Neighborhood Legal Services. Hello there, Ms. Hanson.
Hello. Thank you, Mr. Burek, for sharing your experience with us today and for illustrating the benefits of legal representation for tenants facing eviction, especially tenants with disabilities and limited means. I am grateful for having been invited to speak at today's hearing. Neighborhood Legal Services created the Western New York Eviction Prevention Program to meet the growing legal need for representation in eviction cases within our client community. Neighborhood Legal Services, in collaboration with our partners, the Center for Elder Law and Justice, Legal Aid Bureau of Buffalo, Western New York Law Center, and the Erie County Bar Association Volunteer Lawyers Project, provide free legal representation to eligible tenants facing eviction throughout our 5-county service area. The Western New York Eviction Prevention Program is funded by the Office of Temporary and Disability Assistance's Emergency Rental Assistance Program. We provide representation to tenants residing in Erie, Genesee, Niagara, Orleans, and Wyoming counties. A tenant's need for counsel has never been more apparent. The shortage of safe and affordable housing, the increase in housing costs, the extensive but welcome 2019 changes in eviction law, and the discontent of property owners following the pandemic, among other factors, have converged into a perfect storm, leaving many tenants at risk of being homeless. I have heard manufactured homes described recently as the new landscape of affordable housing. However, I recently reviewed manufactured home park listings in our 5-county service area. Within the sample reviewed, lot rents alone ranged from $324 to $570 per month. These figures did not include the cost of the home. Previously owned manufactured homes are generally selling for between $21,000 and $84,000. Buyers unable to afford these prices may only find substandard, often condemnable homes. New manufactured homes are selling for an average of $108,000. These prices are for the home alone, not for the land on which they're located. For tenants who cannot afford to purchase the home, the combined rent for the lot and the manufactured home can be over $1,000 per month. In addition to affordability concerns, manufactured home park tenants such as Mr. Burek face a complicated legal landscape that is influenced by whether the manufactured home park tenant rents or owns the manufactured home in which they live. Tenants who own their home but reside in a manufactured home park never own the land on which the home is placed. Often, the affordable manufactured homes are in too poor a condition to be relocated. If the park seeks to terminate their tenancies, most frequently these homeowners face either a 30-day notice to pay their rent or vacate the lot, or a 10-day notice to correct a lease violation, followed by a 30-day notice of termination if the lease violation is not corrected. After these notices expired, the manufactured home park can start eviction proceedings, which can finalize in as little as 24 days from filing. If a court grants the eviction, a manufactured home park homeowner has a minimum of either 30 or 90 days, depending on the type of eviction, to not only move, but to also try to sell or relocate their home within the time that they're permitted to be on the property. Imagine losing your ability to live in your $80,000 home in as little as 3 months after falling behind in your rent. Tenants who rent their home from the manufactured home park, regardless of the underlying cause for the eviction, may also receive a 10-day or 30-day notice. But if the court orders their eviction, the tenant may only have as few as 72 hours to move. To further complicate manufactured home park evictions, as 83 to 84% of manufactured home communities are in rural areas, these cases are often heard in rural town and village courts, primarily by non-attorney justices. Due to the expedited nature of summary eviction proceedings, the law requires strict compliance with established procedures. However, when a tenant appears without counsel, compliance with the procedures tends to be more lax, and more complicated procedures tend to be overlooked. This can, and many times does, result in swifter evictions than would have been granted had the laws been followed. Legal representation for evictions can be the difference between homelessness and housing stability, between employment and job loss. Eviction has a demonstrably negative impact on physical and mental health, educational outcomes, and family stability. Legal representation not only results in housing stability for vulnerable households, but it can also prevent the loss of savings that some tenants have spent their whole lives building. Since our creation of the Western New York Eviction Prevention Program in late 2021, Neighborhood Legal Services and our partner organizations have greatly increased our staffing and expanded our representation throughout our service area. As a whole, our program has provided representation in more than 5,900 eviction matters using the Emergency Rental Assistance Program funds. While many of these cases are still ongoing, our program has prevented more than 1,900 evictions and delayed more than 860 evictions. We resolved many more matters without the need for court proceedings, such as Mr. Burick's case. It is our goal to promote housing stability, reduce the likelihood of homelessness through legal representation and advocacy for thousands of clients like Mr. Burick, who face the specter of eviction and its many ripple effects. Yet for our rural service areas, our attorneys must endure pay that is not competitive with the private sector, non-traditional hours, frequent and distant travel, and conflicting court schedules. Increased staff in our rural offices solely with the eviction defense funding is not an efficient method of solving these issues, nor is it an effective manner of addressing many of the root causes of housing instability. Housing instability does not exist in a vacuum. Hunger, poor health, family instability, employment instability, and lack of education all commingle with housing instability, sweeping their victims into a cycle of poverty. One ancillary perk of our recent receipt of eviction defense funding is our ability to refocus some of our general funding into our other services, our other areas of service, including family law, public benefits such as SNAP and cash assistance, health advocacy, disability law, and consumer debt. But funding for these other services still falls short. According to Legal Service Corporation's 2022 report, LSC-funded legal aid only had adequate resources to fully assist with 30 to 37% of civil legal problems for which low-income Americans applied. This is why funding, such as the Judiciary's Civil Legal Services Grant, are so important to help low-income New Yorkers with their unmet needs. Thank you for allowing me this opportunity to highlight the importance of our work and the necessity of civil legal services in providing holistic legal representation to tenants in eviction matters.
Thank you, Ms. Hanson. I have a question for you. About how many lawyer hours were spent on Mr. Burick's case, would you estimate?
It took a little bit of go-between between the manufactured home park and our office. So I would say, as far as hands-on work, it was at least 5 hours collectively.
Yeah, but we're not talking about hundreds of hours, right? And so
Not hundreds of hours.
It's a really good illustration of something we were talking about earlier, which is a very modest investment, avoiding all kinds of social costs. I mean, you can only imagine the cost of Mr. Burek losing his home, having to relocate him, falling into other aspects of the social security net. Very modest investment, 5 hours, even if it was 20 hours of time to avoid that kind of a catastrophe. You can see how the return on that investment is much greater than the investment.
I agree.
I don't know if anybody else has a question for you. I want to thank you very much both for appearing and providing your remarks to us today. Mr. Burek, thank you.
Thank you.
Thank you.
Thank you. Next, we have Rosemary Rodriguez, who is a client of the Legal Aid Society. And I think Ms. Rodriguez is there with her daughter, Christine Rivera. No? Can you hear us?
I can hear you.
Oh, perfect. Welcome, and we're ready for you.
Are you hired? Oh, I got it. Now? No, not yet, no. Oh, no, okay. I'm sorry. Good afternoon. My name is Rosemary Rodriguez, and I am a client of the Legal Society. Hi, good afternoon. My name is Christina Rivera, and Rosemary Rodriguez is my mom.
Welcome to you both.
Thank you.
And we're ready for you to start anytime.
Okay, good afternoon. Rosemary Rodriguez is a client of the Legal Aid Society, and I'm here with my mom to present her on her behalf to express her support for continuing funding the Legal Aid Society and other civil legal services programs that assist New Yorkers like us. My mother is a senior citizen whose only source of income is Social Security. She is also a Medicaid enrollee. In March 2019, she went to a dentist in Manhattan, whom she was referred with her Medicaid Senior Health Partners Managed Long-Term Care Plan. My mom is a cancer survivor. My mom is a breast cancer survivor. She went to the dentist for a dental implant that she needed as a result of her damage done to her teeth while by chemo and radiation, and the nerves by the chemotherapy that she received to treat her cancer. My mother had Medicaid at the time when she visited this dentist's office. Give me 1 second, sorry. When she visited this dentist's office, one day she visited the dentist, and the dentist performed a dental procedure on her that she had been covered by Medicaid. But instead of the billing Medicaid, she was signed up for Care credit card, meaning a credit card, without her consent or her knowledge. Mid-procedure, after the dentist had administered anesthetic medication to my mom and began performing dental surgery on her, the dentist directed my mom, a senior citizen, with limited reading abilities to sign papers, which was not explained to her, and she did not understand. My mother thought the papers were, my mother thought the papers were, that she was signing, it was to treat, what was it? To treat her treatment, to take care of her teeth. At no time did the dentist explain to her that these papers were a credit card application or agreement. The dentist then charged this care credit amount that the same day, for the same day. It says 6,000, but I think it was more than that. I think it was like 19 or so for her service, for the services that my mom that she did for my mom's mouth. So when she did that, she never completed my mom's mouth. My mom first received a notice that she signed up for this credit card, and she received a statement from the Sigourney Bank in the mail. This experience was a traumatic experience for my mom. She trusted this dentist provider to provide her with the care that she went to get and to receive from this office. But her vulnerability was to prey up on, despite informing the dentist, despite informing the dentist's office, she was a Medicaid enrollee, right? They enrolled my mom in a care credit account and charged this account in full for services that was done to my mom's mouth, which was never provided to her, and that she should have been billed to Medicaid. She left the dentist's office that day with holes in her mouth from multiple tooth extractions the dentist performed. While she was there, the dentist pulled her teeth but never provided the dentist implant service. She went to this office for the first time, leaving my mom, she left my mom actually with holes in her mouth. And after that, it made my mom difficult for her to eat. And then she caught infections, and it was actually a bacteria in her mouth as well. So after she received the billing statement from the Sigourney Bank in the mail, she realized that what had happened. My mother tried unsuccessfully to resolve this issue on her own with my help. She contacted the dentist's office to request a refund, which the dentist's office refused to, even though they failed to perform the services for which she charged this care credit account. Then she filed a complaint with her Medicaid managed care provider. She made several payments on this care credit account with my help, even though she did not believe she owed this debt. And despite the financial strain it put on my mom, my family, it actually, she believed that she had to, because she was worried about the debt collections and will harm her credit. Something went out.
We can still see you and hear you.
Okay, sorry about that. Something went out. Sorry about that. Okay, so The bank account assists her with the filing a Medicaid complaint for the service improperly billed to her by this dentist's office. In June 2020, they sent a cease contact and verification demand letter to the debt collection law firm seeking to collect on the Sequoia Bank Care Credit account. In August 2020, they sent a cease and desist letter to Sequoia Bank and the dentist's office, disputing the account and all transactions made on it, informing them that my mom did not owe this debt and that my mom, a Medicaid enrollee, could not lawfully be billed for the services, and demanding that they could collect, and demanding that they stop collecting. This matter and discharge this alleged debt. They worked with the health law unit at the Legal Society and assist my mom with filing Medicaid billing complaints regarding this dental provider with the medical managed care provider, and they referred my mom to a free financial counselor for assistance. Oh boy. With a non-litigation financial matters, including damage to her credit score as a result of the care credit account. Then in November 2020, Sequoia Bank sued my mom in Queens County Civil Court for the debt of my mom. Contacted the Legal Aid Society Consume Law Project again for assistance. They assist with her drafting and filing an answer and discovering the bans on the continue to advise her while she await for the court to schedule the first court appearance in her case. During this time, Sequoia Bank continued to the state additional subsequently communications they sent to my mom that they investigated this matter response to the 2019 dispute. Letter to Sequoia Bank, and that they found no fraud and the account balance was valid. Other than these communications, there were no further actions in the case. For about 2.5 years, we waited for a court date during the pandemic. Finally, in June 2023, before the court date was even scheduled, Sequoia Bank agreed to discontinue the case against my mom. The result would never have been possible without extensive efforts by the Legal Aid Society proving that the debt was not owed. My mom and my whole family are tremendously thankful for the work of the Legal Aid Society. Though the experience has been traumatic for my mom and family, the dedicated assistance has allowed my mom to avoid garnishment and levy of her money and to get back on the path to financial and medical recovery. Oh, Jesus. Okay. Sorry. Yeah, I'm good. I just got stuck. Illegal. Give me a second. Hold on. No, I got it. I'm trying to. It's the Legal Aid Society provides. Okay, sorry about that. The Legal Aid Society provides essential legal services, advocacy for New Yorkers. I've been told that so much of what legal aid does will not be possible without the consent, investment, or disparity civil legal services findings since 2011. Thank you for the invitation to appear before you today and share my story of my mom. Thank you so much.
Thank you so much, Ellen. And I'm so grateful that she was the one that helped me and with all this case and paperwork that she did for me, and she would reel me to make copies and to send them. And she helped me so much that I appreciate her so much, because I would never get this help because I don't have money to get a legal aid. And I thank this, the civil, what was it? The Legal Aid Society, for them to helping me also with this situation that I went through, and it affected me a lot. And still to now, I still don't have my teeth. But I pray to God that someday I would, because it damaged my mouth. I have got infection. I can't eat well. I'm embarrassed to
speak, to talk in front of people.
Yeah. But I thank so much this aid.
We want to thank Ellen for helping us.
Helping me so much with all this that I went through in the Legal Aid Society. Thank you for hearing us. And my daughter that helped me too. Thank you.
Thank you, guys.
No, thank you both for taking the time to explain what must have been a horrible, I mean, sometimes I wonder if I live in the same world as other people, because I can't imagine going in for surgery and having somebody give me a credit application to sign, not explaining what it is.
While she was in anesthesia.
No, it's unbelievable, unbelievable. It's inhumane that someone would act that way. But it is, as you said, a wonderful thing that you were able to find legal aid and that they were able to help. Obviously, you're still suffering, but at least the debt is gone and the lawsuit is gone and all that trauma is gone. I don't know if anyone had, I think Justice LaSalle has a question.
Just quickly, first of all, Ms. Rodriguez and Ms. Rivera, I think it's great that you're helping your mom here today, and I'm sorry for what you've gone through. Just one question, though. Are you aware of whether or not the dentist who treated you or treated your mother was referred to the Office of Professional Medical Conduct? Did your lawyers tell you that was done? That might be a better question for your
I didn't
attorney.
hear. I can't hear you.
Hold on, give me one. I'm trying to put the volume up. Just give me 1 second.
Sure. You good now? Can you hear me now?
Yeah, I got it.
Okay.
Thank you.
Again, I wanted to, well, first
Thank
of
you
all,
again.
thank you both for being here today, Ms. Rodriguez and Ms. Rivera, for helping your mother here this afternoon. My question is, just, there's a concern obviously for what happened to you, but, a dentist who, I would imagine you're probably not the only family who suffered at the hands of this dentist. I would imagine this sounds probably like, course of conduct if I was guessing, I guess. Are you aware of whether or not the dentist has been sent to to the Office of Professional Medical Conduct? Do your lawyers fill you in on that, or whether or not the doctor is being charged or investigated, I should say, for this, which seems incredibly unethical behavior? Are you aware of that?
We actually, it's actually being investigated.
Oh, it's in the process of investigation? Okay. Thank you for answering my question. Thank you, Chief.
You're welcome. Thank you.
Thank you so much.
No, thank you again. And we can now hear from, from Adrian Holder, who is the head of the civil practice at the Legal Aid Society of New York, and is also a member of the Permanent Commission on Access to Justice.
Yes, thank you. And thank you to Rosemary Rodriguez and Christine Rivera for sharing the personal and difficult situation you endured on Ms. Rodriguez's case. Good afternoon. Adrian Holder. I'm the Chief Attorney of the Civil Practice of the Legal Aid Society. I also serve as a member of the Permanent Commission on Access to Justice. Thank you, Chief Judge, for noting that. I'm very proud to sit with such an incredible group of people. And I first want to thank Chief Judge Wilson, Presiding Justices LaSalle, Renwick, and Whalen, Justice Clark, and Chief Administrative Judge Zayas, and New York State Bar Association President Lewis for the opportunity to address you today. I really do appreciate how engaged you all have been throughout this entire hearing. I've enjoyed your comments as well as the testimony that we've had today. But I'm also aware of the time, and I know it's been a long afternoon, so I'll try to be brief. Although there's always more work to do, today, as a legal services community, we highlight some of our successes. So much of this work would not have been possible without the consistent investment of judiciary civil legal services funding since 2011. Investing in legal services is a long-term investment in the fight against racism, injustice, and poverty. We are also grateful for the recent commitment to incorporating cost of living adjustments into the JCLS funding. This crucial adjustment has been instrumental in helping us navigate the ever-increasing operational expenses such as rent, health insurance, and technology that we encounter year after year in our line of work. On behalf of the Legal Aid Society, I thank you for your continued support and again for the invitation to share a part of our work with you today. The Society's Consumer Law Project in our civil practice represents and assists low-income consumers in a range of matters, including consumer debt lawsuits that involve credit card debt, medical debt, and financial products, student loans, and rent arrears, affirmative litigation for violation of consumer rights, including under the Fair Debt Collection Practices Act, victims of fraud, identity theft, financial abuse, and scams, and advocating on their behalf with financial institutions as well as government regulators. Through this work, we hear regularly from clients about challenges they face navigating the court system and have seen firsthand the critical role that access to legal services can play in determining an individual's ability to assert their rights and seek justice. There continues to be a significant justice gap when it comes to consumer debt collection lawsuits. You've heard that earlier from my colleague Sal Karan, and I think that many of you all are very familiar with it. Every day, distressed New Yorkers learn that their wages have been garnished and their bank accounts frozen due to these cases. Recently, we have seen an increase in medical debt cases involving medical credit cards and other predatory financial products. As Ms. Rodriguez's case shows, medical debt cases involving medical credit cards has real consequences for people. Similar to her situation, these products are often offered to patients when they are in a significant stress and when they're even eligible for free care through Medicaid. In Ms. Rodriguez's case, the dentist she went to for care improperly billed and collected payment from her for Medicaid-covered dental care and engaged in improper and deceptive enrollment processes regarding the Synchrony Bank Care Credit account. As a Medicaid enrollee, Ms. Rodriguez could not lawfully have been billed for these services, nor could her account be referred to a collection agency. On the dates of service in question, she was in receipt of full Medicaid benefits. She informed the dentist that she was a Medicaid enrollee, yet Ms. Rodriguez subsequently received bills for dental services that were or should have been covered by Medicaid, but were instead charged to Ms. Rodriguez and to the care credit account. Furthermore, the dentist's practices related to this care credit account also violated several provisions of the 2013 settlement agreement entered into by GE Capital Retail Bank and Care Credit Card with the New York Attorney General. In addition, despite obtaining assistance from our tenacious and talented staff attorney, Alec McCormick, and repeatedly disputing this debt with the creditor and debt collection law firm, sending her pre-litigation debt collection letters, submitting complaints to her Medicaid managed care provider, the creditor in her case still sued her in court as an attempt to collect the debt Ms. Rodriguez was adamant she did not owe. When creditors sue individuals like Ms. Rodriguez for these debts in New York courts, they are represented by attorneys in nearly 100% of these cases. In stark contrast, 97% of individuals sued for consumer debts in New York courts do not have an attorney. While the amounts sought in many consumer debt cases may be considered small, they cost and impose on the individuals sued are significant. For defendants in consumer credit cases, the risk of a civil money judgment being entered against them is a very real, and the consequences of these judgments are great. Creditors enforce judgments through wage garnishment, levied bank accounts, and liens on enforced sales of real property. Other consequences include harm to credit, which negatively impacts access to housing, employment, and general credit worthiness, and perpetuates the cycle of poverty and harms financial stability for litigants and their families. Not to mention that the significant non-monetary costs on defendants and judgment debtors in these cases, including emotional and psychological harm, distress, embarrassment, and humiliation imposed as a result of entry and enforcement of judgments. So, in conclusion, and as we wrap up this hearing, I want to just say a few things, and also about Ms. Rodriguez's case. The Legal Aid Society was able to settle a big dental case, ensuring and expanding Medicaid managed care services and dental services. We have now some of the strongest provisions in the country to help Medicaid recipients, and our health law unit has been contacted to try to help Ms. Rodriguez in going forward and actually getting the care that she deserves and what she's now entitled to legally to get it all completed. In addition to that ideas, of course, that this debt that was erroneously brought to her through a medical credit card has been finished. But today, as the testimony presented by a range of experts and civil legal services providers, we've heard the case made for addressing the access to justice gap with continued and increased funding for civil legal services, and the imperative of achieving pay equity with our peers and public interest law working in county and state government positions to retain staff. These interconnected issues have a profound impact on the accessibility, the quality, and sustainability of legal assistance for those who need it most. First and foremost, let me recognize the extraordinary strength of our New York State legal services community. I have often said that there is no better community of legal services providers than our community here in New York. I'm also a member of the New York Legal Services Coalition and proudly stand with all of them. The community of providers stands as a beacon of hope for countless low-income individuals and families who face legal challenges. Our legal services organization, staffed by dedicated attorneys and professionals, work tirelessly day in and day out to uphold the principles of justice and fairness. They are the front lines of defense for vulnerable communities, providing critical assistance in housing disputes, family matters, immigration cases, government benefits, and more. And I'm proud to stand with them. However, that brings us to the pressing issue of funding. While our legal services community does remarkable work, we operate under constant financial strain. The demand for civil legal services far outstrips the available resources, leaving many individuals without the representation they desperately need. This imbalance undermines the very principles our legal system is built upon. Therefore, we must advocate for increased funding for civil legal services. Adequate funding is not merely an investment in legal aid, it is an investment in justice, equity, and the protection of some of the most vulnerable members of our client communities. Therefore, I respectfully request a substantial increase in JCLS funding to help close the justice gap and to meet the urgent needs of our communities, and I'm encouraged by what I've heard in testimony today. Furthermore, achieving pay equity with legal positions in government agencies is paramount. Currently, the pay gap between our legal aid organizations and government agencies is substantial, making it difficult to recruit and retain experienced legal professionals. To continue providing high-quality legal services, we must close this gap. Competitive salaries will not only attract top talent, but also ensure that our legal aid organizations can retain experienced staff who bring invaluable expertise to their work. Therefore, we respectfully ask that you develop a plan to engage in discussions with the governor and legislative leaders to work on a multi-phase plan to achieve pay equity across government-funded public interest legal systems. As a community of legal services providers, we have witnessed and been the beneficiaries of your leadership on access to justice issues that serve as a blueprint for other states in our nation. With the support of JCLS funding, we are closing the justice gap. We appreciate your leadership and your partnership. On behalf of the Legal Aid Society, thank you for your continued support and for the opportunity to speak with you today.
Thank you, Ms. Holder. It's always wonderful to hear from you. I don't know if anyone has a question for you.
Thank you for what you do, and thanks for what you do for the Bar Association as well, Adrian.
Yes, I am on the House of Delegates, and it's good to see you, my president.
I think we are all on the same page here, and we are very hopeful. I mean, the one unifying thing I think that, in listening particularly to the clients today, is that none of them, that they each found themselves in really an unfathomable legal mess, and none of them had done anything to get themselves into that mess. They were living their ordinary lives, they were making ends meet, and as a consequence of nothing that they did, unless you count getting sick as something you did, you can imagine what would have happened had they not have had a lawyer. Not hard to imagine. Very clear what would have happened if they hadn't had a lawyer. And we don't want people to wind up on the wrong end of that simply because they couldn't find a lawyer, when they had done nothing wrong, and we would all be worse off. Not just they, we would all be worse off had they been unrepresented. So thank you for everything that Legal Aid does, and for all the other providers here. I assume they're offline now, but we all very much appreciate their efforts.
And I thank you.
That concludes this year's hearing. It doesn't by any means conclude our work, but thank you all for being here.
Thank you, Chief.